Division bench item sitting singly. Remote PC.
The appeal is allowed and the impugned judgment dated 19/1/2022 is set aside. Recently, the verification report of the EAC BOTSA dated 6/5/2021, approval letter dated 8/6/2021, approval order dated 9/6/2021, forwarding of the approval order dated 12/6/2021, and forwarding of the approval of the newly elected selected VCMs bearing number 40 bearing dated 14/6/2021 issued by the EHC BOTSA, which were set aside and quashed by the impugned judgment and order, are all restored and will be in full force and effect.
Lordship plan.
May it pleases your lordship.
Division bench. Single bench continue.
May it
Yes.
pleases your lordship. In item 7, here file an affidavit by the respondent number 4, my lord. That will be allowed to call.
May please, sir, Lordship. Lordship, I beg to mention for listing a matter. Lordship, it was last listed on 19/12/2020.
Give it to the court master, they will have to make some adjustments. All prayers for listing, give it to the court master.
May I please, your lordship? Lordship, I beg to mention item number 27, lordship. Lordship, matter may be taken up in the next week, lordship.
After 2 weeks, if it's adjourned,
Obliged.
20.
7, lordship, 27.
You are for the petitioner.
Lordship,
Just a moment, there is something there. Item 27.
Item 27.
Next,
May I please, your lordship,
just wait for some time.
mention item number 15, my lordship. It may be listed on 26th, my lordship. My senior is having some difficulty today.
List on 26/4/20 requires paid for by the council for the petitioner.
27.
adjournment.
May I please, your lordship?
You see, here the issue of maintainability was taken. You'll have to address that.
In fact,
And
my lord,
after that, this matter has been adjourned twice.
Lordship, lordship, 1 week, lordship. Some personal difficulty of my senior lordship.
That's okay, but you see, when the question of maintainability is taken up, you have to address on that.
this honorable court, my lord, wanted my assistance, madam.
Yes, yes, we, that's
have
why
not-
we,
In fact, the parallel proceedings are going on, my lord. They are asking for
that's why I
same,
flagged it.
same relief, my lord.
That is why I flagged it. We
Yes.
wanted to,
Lordship, next week,
Senior.
lordship.
no, not next week.
Then, my lord, let it be the week starting from 13th of May, my lord. Second week, I have some difficulty.
Okay,
Or any other date convenient to your
it's okay, 13. Matter stands adjourned on the prayer made by learned counsel for the petitioner. Mr. P. N. Goswami, done in addition, that the journal is present. Raised again on 13/5/2024. Next matter, as the issue of maintainability has been raised. The petitioner shall not take an adjournment on the next date,
But may I pray on 14th or 15th now?
15th.
Fine.
May 15th.
Deeply aware.
Obliged lordship.
May I please your lordship, I beg to mention item number 12. Kindly the matter may be fixed on Friday.
Okay, list on 26/4/2024 is prayed for by the counsel for the petitioner.
May it please your lordship. Lordship, in item number 99 for the petitioner, lordship, we need some time to file a affidavit in reply. Lordship, we have
You have
taken
informed the other
consent,
side.
lordship, we have taken consent from the others.
Okay. Both sides are represented on the prayer made by standing counsel for the NF Railway.
Lordship,
The matter stands adjourned today. List after 2 weeks.
lordship,
So as to enable him to file affidavit in opposition.
reply.
Affidavit. So you are the British
And for
petitioner.
the petition,
Okay, I'm petitioner. File affidavit in reply. Okay,
I'm all right.
Lordship, I beg to mention item number 13 of today's list, with the concern of the writ petitioner, I on behalf of the newly implemented respondent number 7 and 8, seeking time for filing in affidavit in opposition.
item 13,
35.
35. Okay, both sides are represented on the prayer made by counsel for respondent number 7 and 8. Matter stands adjourned to enable her to file affidavit in opposition in the matter. Just after 2 weeks,
3 weeks, lordship.
3 weeks. Is there any interim order operating?
No, there's no interim. No interim order. May I please, your
Just-
lordship?
just- Just wait, please. No, someone senior to you is there.
My lord, I beg to mention item number 20, 20.
20. Yes,
I'm mentioning on behalf of Mr. P. J. Sekia, my lord, I pray that this matter may come up after 2 weeks, my lord.
okay, here adjournment slip was given. Okay. Both sides are represented on the prayer made by counsel for the petition. Matter stands adjourned today. List after
2 weeks, my lord.
2 weeks.
There is interim order that may be complete.
Interim order extended. Okay,
All right.
yes.
May I please, your lordship? Your lordship, I beg to mention item number 24 from the Delhi court list. The matter may be adjourned for the day, your lordship.
You're for the petitioner.
Yes, lordship.
Both sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List after 2 weeks.
Your lordship.
Yeah, please. My lord, I like to mention item number 38, my lord. I'm for a petitioner, my lord. I may be allowed to do this petition from instruction of the line. I've taken consent, my lord. In the 38.
Upon instructions, Mr. D. Gogol, counsel for the petitioner, seeks to withdraw this writ petition. The government will be appearing, probably will be there, Mr. S. Barbat on the government advocate. And NCHSC who appears,
RM Das. RM Das.
and Mr. Aram Das, the standing counsel for NCHSC. Are present. Matters are dismissed on withdrawal.
Highly obliged.
May I please, your lordship? Prayer for listing, lordship.
That is
May I
all.
have-
Court master.
Okay.
Daily list item 1 for motion. Supplementary list, delivery of order, item 48.
We are proposing to appoint Honorable Mr. Justice Arup Kumar Goswami, former judge of this court and former Chief Justice of Chhattisgarh, Andhra Pradesh, and Sikkim as sole arbitrator. We are issuing a direction to the petitioner to take steps so as to enable the proposed learned arbitrator to make disclosure as per requirement of section 11(8) of the Arbitration Act. Steps within 3 days, list from 31/5/2024. This also covers item 49. 49 also same.
Item 1,
Hello, may I go to the order? May I go to the order once?
item 1 for motion.
None appears on call for the petitioner. By order dated 3/4/2024, this court had recorded that order dated 25/2/2022 has not been complied with. Compliance is still not made. Therefore, it appears that the petitioner is not interested to pursue the matter. Matter is dismissed for non-prosecution.
May I refer my lord's indulgence, my lord? Justice A.K. Goswami perhaps would not be able to, because the matter is against the government of Assam. He is now the president of the State Human Rights Commission, my lord. Perhaps he would not like to take up the matter. There is that difficulty, my lord. I'm sorry to have.
But I think arbitrator would not have any, it doesn't have a bearing.
There could be a possible difficulty. But my lord deems fit now.
Oh, okay, let me take a call there.
Very well. Deeply appreciated.
Let me take a call. This appointment of arbitrator may change.
My lord.
Please,
My lord, after we take steps, even the arbitrator can deny it, and then we can place it on 31/5.
no, but once an apprehension is expressed right now, we will have to take a call.
My lord.
I'm deeply appreciated.
In the evening, last part of the evening, you may.
My lords.
We'll clarify.
Item 2,
Same order.
item 3,
May I please, your lordship?
Yes,
Lordship, kindly adjourn the matter for 1 week.
for
1 week.
just 1 moment. Yes, you've got instructions.
Lordship, they have got the instruction, Lordship. How much amount was allotted? Yeah. Ninety 97.
Is it joint?
Publisher. Lakhs. General manager. Technical engineer, delivery 1 crore distribution. 56 crore distribution. Non-solution. Building division.
You file an affidavit then.
Okay,
terms of this,
their
file an
affidavit,
আপনার affidavit আছে।
Yes. So then we'll close the matter.
Their affidavit, they have already put it on their affidavit.
I don't think so. Is there in your affidavit? No. No.
We have filed.
No, is this fact available there?
Lordship, yes, it pays 85 Lordship. It's a report of the executive engineer PWD. Filed by resolution number 3 Lordship.
No, the page numbers are changed. Now it is 197.
Oh. Last page. One forty eighty-five. 80, 130, for this purposes. 84, 85. 225.
Your officers, can you find out where they have given the date?
Date to the.
But then this is inconsistent with what you're saying in affidavit. In our affidavit, you are saying 1,07,63,200.
Yes.
In your report, you are saying 84,26,000.
Yes, Lordship,
So we
that,
request not to
that was,
condemn.
that was estimated by the PWD
I
engineer
understand.
later on.
But if
It
the
was-
two documents are in variance, we issue a
Yes.
notice of contempt.
Lordship,
Your figures should match.
because our estimated amount was by the PWD department, it was,
No, now we
Uh,
don't know. I asked you to give it on record. You say that it is there on record. In the record, it is variance with the report. So what do I do?
so later on, Lordship, the 84 lakhs were approved by
I'm not
the
concerned what has
Kala.
happened later on or now. But if it is not, if it is a mismatch and your statement is correct, then it is on record, then we issue a notice of contempt.
So Lordship, I have mentioned in,
No, you see, we don't have that much of time, Mrs. Bora. With this many matters on board, we don't have time to spend on a matter. You see, once I looked at this record, I told you that it is not there, and you said it is there.
paragraph 20, Lordship, in your affidavit, we have explained, Lordship. Paragraph 20, Lordship.
Paragraph 20.
আমি ফেরিলে কোথায় ছিল? forsake the same. Lordship, got it? Paragraph 20, Lordship. With regard to statement made in paragraph 18 of the writ petition, the contentions made by
No,
the
you see,
petitioner are
Mrs.
categorically
Bora,
denied.
we don't have, I told you, we don't have that much of time. If it is this.
No, it was sent for
No.
cross-check.
You see, page 20 overrides your affidavit. This is the instruction of March 20.
Yes.
If your affidavit is overriding this, we end the matter here.
That,
We set aside this 83 without any notice. You pay 1 crore rupees.
that Lordship,
And this, no. You see, we are very clear. Government is making an estimate of 87. You are saying in your affidavit 1 crore. So this 20 lakh will be spent by you.
no, that was
In
given
addition
by the
to-
PWD Lordship to
We don't
the
know- we
NHI
don't know. I told
DCL.
you again, this for the 5th time I'm telling you, we don't have time. Your figures in the affidavit and this does not match. I have other two ways to do it. Either I accept your affidavit and the matter, or I issue a notice of contempt to the respondent who has filed respondent number 3 who has filed the affidavit.
Oh, let me clear the Lordship,
it?
additional
That's
affidavit.
right.
Yes,
Even without looking at your affidavit, I told you it is not there. That means I have spent some time reading this.
actually,
No, don't give
let
those
me,
explanations.
I'll file an additional affidavit.
Don't give those explanations. In morning hours to have a debate on these matters doesn't look nice. Both sides are represented on the prayer made by Mrs. R. Boran and standing question for the NHI DCF.
NHI.
The matter stands adjourned to enable him to file affidavit to bring on record the stand of the said respondent. regarding assessment and compensation of the ISRAs. Just after 2 weeks.
Apply.
Item 4,
Jan item.
May I please, your lordship?
Yes.
May I please, your lordship? This is an arbitration petition, lordship, for appointment arbitrator, lordship. The petitioner is the landowner, lordship. And one irrevocable power of attorney and agreement for development executed between them, lordship.
Okay, issue a notice.
Lordship.
Issue notice, Parvez has come to counsel for the petitioner. Issue notice on this application under section 11 of the Arbitration and Conciliation Act. Notice is made returnable on 10/6/2024. Next, the petitioner shall take steps in 2 days to service of notice on the responded by registered post. List on so and so.
Keep it.
item 5,
May I please, your lordship?
Yes. You filed your returns, your
Instructions are awaited, my lord. And your lordship may please to peruse the last order.
Like we have an instruction, but from the instruction, they have land in 2 different areas. One is in Bilasipara subdivision and another is Dhubri. So report of the register of the Dhubri is awaited, but from the Bilasipara division, the sub-registrar's report is here with me. It is with regard to that old 618 DAG. Yeah.
But so far as the report is concerned, my lord, at page number 39, it does not speak that the land falls into 2 different subdivisions. Page number 39, my lord.
in this trace map at page 26, where is your land?
My lord.
26.
That is, my lord, at 2357, my lord. In the small box. Two, 357, my lord.
It could not have been in 2 different subdivisions. Because if the land is in 2 subdivisions, you will not get one trace map.
My lord.
But the circle will change.
Circle with 6.
So circle A will not have a trace map of circle B. Supposing Kamrup and Kamrup Metro, there is a land between these 2 areas. I have doubt that you will get a single trace map. Or if there is 2 subdivision, let us say Kamrup and
pin number no serial number.
Nagarbera. So let us say that 2 subdivisions. Maybe there is a joining land. I have my doubts. Unless you show that it is some same circle. Where is your instructions? Just let me see that.
This is very precise. This is very precise, and but thing is that if at all we can produce that volume book whereby they have enumerated all the ducts.
But Mr. Burma, I'm not understanding these instructions to you. The case of the petitioner is that his land was Pata land. Then it was, part of it was made Sarkari. Correct?
Yes.
So why do you need this, this deed number 248?
618.
No, I understand, but what is the requirement of this deed? Because if the Pata is originally the same Pata, then I think perhaps you'll have to advise the deputy commissioner to know how to look at the land revenue records. He'll have to go to the last previous chitta concerning the land when there was a single Pata land. Then he'll have to find the next entry in the chitta. And he'll come to know what has happened.
Can I have a detailed, we can file a detailed affidavit as regard this? Because these,
You see, but if the highest authority in the land revenue does not understand this
I can understand,
aspect,
I can understand.
somebody will have to advise him. Here we only have you to look upon.
We would try to guide them to have that appointment.
Please, because this is, does not make sense.
Yes,
He may have a doubt that the original sale deed did not have that amount of land. Then we understand he's wanting to look at the sale deed.
Yes.
But when there's an entry in the Jamabandi showing a land area, he has shown a trace map where that is a common land,
Yes.
page 26.
Yes.
Then if there's a land bifurcation, it will be the deputy commissioner to look into the chitta and tell us. If there is a, suppose you got it Kartan of that land, then for the Kartan, there will be a corresponding entry in the job.
that's true.
It doesn't say that.
In respect of the same Patta Milot, 1 bigger land has already been Milot reinstated as Patta land Milot, but the so far as it with regard to that number Milot 2356 Milot, but 2357 remain left Milot. So a
We are
separate Patta
issuing
has
notice,
also been
otherwise
issued.
it's coming in motion. We can't pass any orders. We issue a notice of motion. Okay. In the motion stage, it's very difficult to dispose of petitions. But Mr.
A. Ali.
A. Ali, from the counsel for the petitioner. By filing this writ petition on Article 226 of the Constitution of India, the petitioner had prayed for a direction upon the respondent number 3 to give effect to the proposal forwarded by respondent number 4 for correction of the land records and restoring the status of the petitioner's land as a Pata land. The matter was deferred by order dated 18/3/2024 and 27/3/2024 to enable the government advocate to obtain instructions. Next, the London, Mr. S. Sharma, learned government advocate, S. Barwar, on the government advocate, has produced a copy of letter dated 27/3/2024 received from the additional deputy commissioner within bracket revenue Dhubri. informing that they are awaiting receipt of volume book regarding deed number 248. It is 18/1/1971. There's no explanation as to how this said deed is relevant. Let's be there as it may. I should return over 4 weeks. Requisite extra copies of the petition be served on the government advocate in course of the day. Issue notice including notice of the prayer for interim relief. Next slide. Having regard to the nature of claim made by the petitioner that the land was originally a Pata land and a part of it was made government land without any acquisition proceedings, as an identity measure, the respondent authorities, specifically the Deputy Commissioner Dhubri, shall not avail the petitioner from the you're not describe the land which is not in your, which is made Sarkari. Of the government land created out of original lot number 15
No, my lord, 2357.
2357. Of which village?
Village, Suapata Part 5. my lord.
Village
Suapata Part 5.
Swapatha. Please write it and give it to the courtmaster.
Yes, my lord.
Village Moja and
Circle.
circle.
Yeah.
List.
Obliged.
Give a date after 4 weeks. Returnable house. Yes, item 6.
Obliged, my lord.
In this case, madam, notice of motion was already issued, madam, perhaps wrongly listed in motion column. Madam, I am in receipt of the instruction. Next week, madam, may fix, madam, I will file my affidavit. It's almost ready, madam.
And Mr. R.B. Cook and counsel to the petitioner. As well as Mr. P. N. Goswami from the additional advocate general for the state. Next part, it appears that notice of motion has already been issued
3/4/2024.
by order dated 3/4/2024. Additional advocate general summons that he has received instructions and will be filing an affidavit within a week. List on, you after 10 days a date.
6 to 10 needed. Again,
Last date,
Huh?
last date, third of
me.
last date a submission was made that your father was.
Yes, he's still in hospital, madam, at Delhi. I was there for 10 days. Now my brother has come, so I have come back. I will again have to go next week.
But I appeared for R6 one.
Sir, Jia within council for R6. Item 7.
Item 7.
In this case, on this,
Yes,
in this case, on behalf of the state, we have filed the affidavit. It is not in record also.
Saturday, they have filed.
So,
At least, my lord, a week time should be given to give a reply, my lord.
uh,
Only I am asking for a week only, my lord. There is some urgency to the government side also, because there is an interim
notice
order
was
which is
already
passed by
issued.
this court.
notice has already been issued here
I think, my lord.
by order dated 4/4/2024.
Any date which is convenient to my learned friend.
notice was issued
4/4.
Ah.
When do you want?
on 30th of May for final disposal, 30th of April, 30th of
30th
April
of April,
for final disposal.
final discussion. I'll give you
Final disposal
reply.
I'm not saying.
Lordship,
Final disposal I'm not saying, but I'm fixing it on that day.
and lever maybe that observation, Lordship.
You make a prayer. Advocate general making a prayer will be taken up, but I don't want to bind my. if
But
you are
very
there,
small
I'm
short
taking up the
matter,
matter,
Lordship.
huh.
Anyway, Lordship.
If I am there, I'm taking up the matter, but
Lordship.
I'm not binding my
Lordship.
honorable colleague judges. Three, 3-0.
30th of April. That's a Tuesday.
By Mr. D. Das, the senior counsel, assisted by Mr. K. Talukdar, counsel for the petitioner. It appears that notice of motion has already been issued by order dated 4/4/2024. Mr. D. Cycle and an additional, advocate general, assisted by Ms. Ann Burman, government advocate. Submits that he has received instructions. and
We have filed
already-
affidavit
already-
and there is a urgency in the matter, that observation.
And already filed an affidavit in opposition on 19, 20/4/2024. He expresses some urgency in the matter. Next, accordingly, list in the admission column on 30/4/2024.
Lordship.
We'll give a reply.
Highly obliged.
There is an interim
Liberty-
audit which will
liberty to
continue
reply.
till then.
The petition is granted. The interim order passed with stands extended till the next date on this law.
Highly obliged.
Item 8.
May I please open?
Yes.
Lordship, kindly matter may be passed over for the day, Lordship.
Here
it
we had
is-
issued a question of maintainability.
Yes. Lordship, engaged council is out of station, Lordship, some important matter. They inform me to.
Okay, both sides are represented on the claim made by London Council for the petitioner. The
So
magistrate
that may
judge
be
on the day. Next paragraph. On the next date, the counsel for the petitioner shall address the court on the maintainability of the petition. List. Next week.
30/04.
No, 30 is Tuesday.
Oh, sorry, sir.
29. 29/4.
29/4.
Obliged, Lordship.
Item 9.
May I please, your Lordship?
This is something we don't have power and authority to see how the alignment of the road will be
No,
made,
my lord, what
whether
happened?
it can be turned, whether it
But
can be.
earlier case, they have done it. In this case, I take your lordship, my lord, to one resolution, page 34. They have changed the alignment, my lord. My lord, I have made the representation to the deputy commissioner, deputy has forwarded to them. They have inspected the area. Now, instead of that, I am ready to surrender my paddy land, so that my property may be saved, my lord. Our properties at RCC building, Assam Tribe, we have not any other land to construct our home, my lord, homeland. Only 20 meters, my lord. And project is not yet finalized, my lord. Just survey has been done. Notification has been given in the Gazette. Our land has not yet been acquired, but number has been given. Proposed acquiring.
Acquisition is not done.
No.
Let me issue notice then.
And in the meantime, our representation may be disposed of if possible. That is the ends of the matter. If they consider it is violent, otherwise we have to bow down to them.
But Mr. S. C. Viswas, and counsel for the petitioner, also heard Mr. S. Barwar, government advocate. Revenue, you are there, this PR Mathur, understanding also for the revenue department. And Mrs. R. Borat, and standing also for the NHAI.
5 and 6.
That's one.
5 and
6. You should notice of motion including notice on the prayer for interim relief returnable on. How much time?
Lordship, 2 weeks time.
2 weeks. Give a date after 2 weeks. Returnable on so and so. Requisite extra copies of the report should be served on the Learned State and Departmental Council in course of the day. Next paragraph, the pendency of this repetition shall not be a bar for the
13th of May.
Respondent number 6, who will dispose of, respondent number 6 will dispose of representation.
Yes, my lord.
Will dispose of the representation of the petitioner.
Tata decision.
Is it 3/3/2024?
General Manager P.
Petitioners, huh? It was forwarded.
It was forwarded by
to the
Deputy
State
Commissioner, my lord.
Authority by the additional Deputy Commissioner, Karimganj. Right, letter dated 11/3/2024. List on so.
13th of
Give copy. भाई जो अपने extra copy लगेगा.
Item 10.
May I please, your lordship, the matter relates to non-appointment of arbitrator, lordship. The Ministry of Road Transport and Highways on 21st February 24 already appointed arbitrator, lordship. So repetition began in versus minor.
Show it to Mr. Das. Mr. Das, these are notified authorities.
Yes.
So we close this repetition.
Yes, yes.
Pass it on. By Mr. A.K. Das, the counsel for the petitioner. Mr. S. Barwat and government advocate appearing for the state. Mrs. R. David and CGC appearing for the Union of India. Union of India is number 1.
For respond number 2, lordship, I am appearing.
For respondent to Mr.
It's R. Bora on behalf of
R.
C. Bora.
Barwat and counsel appearing on appearing for respondent number 2. And Mr. R. Talukdar and
R.K.
standing
Talukdar, my
counsel-
lord.
R.K. Talukdar and standing counsel for NHI
DCL,
ECL. Respondent number
3 and 4, my lord, but
3 and 4.
the-
Okay. We will do the round. The petitioners, agreed by the compensation awarded for acquisition of land for national highways. Had filed a protest which was not acted upon. And accordingly, this petition was filed on the article, has been filed on Article 226 of the Constitution of India. Next paragraph. The learned standing counsel for the respondent numbers 3 and 4 has produced a copy of Gazette of India Extraordinary dated 21/2/2024, by which white notification number S full stop O full stop 805 within bracket capital E bracket closed dated 21/2/2024. Special Secretary to the Government of Assam has been appointed as arbitrator under Section 3G of the National Highways Act 1956. Which includes the district of Tinsukia. The special secretary who would be the secretary?
Revenue and Register Management Department, Revenue and Register Management Department, my lord,
Special
Government of
secretary.
Assam.
But that is not given here.
Yes, lordship, but Revenue Department, lordship.
Although it is not specified in the said gazette notification, so about the standing person for respond numbers 3 and 4 has submitted that the competent authority, that as per his instructions, the competent authority to act as arbitrator is the special secretary to the government of Assam, Revenue and Disaster Management Department, government of Assam. According to this, the petition stands close with liberty to the petitioner to move the said authority, if so advised. The copy of the gazette is retained as part of the court.
Less, my lord.
Item 11.
Please, Lordship. Lordship, section 64, right to inform, right to, my lord, fair compensation act prescribes certain limits, my lord, both for the, my lord, deputy collector as much as, my lord, for the aggrieved party. But in this case, my lord, none of them has been complied with, my lord. Now, without, my lord, making implementation of this both part, my lord, the matter has been referred to the, my lord, authority concerned. The case is now presently pending before the authority for, my lord, other proceeding. My lord, section 64 is indispensable, my lord.
No, you see, if this assessment is incorrect,
Madam.
then what is the remedy available, statutory remedy available is, what is the remedy?
My lord, that matter may be referred to the authority for redetermination, my lord. But question is that, my lord, prior to the lordship, just have a look to section 64 for a moment, my lord.
64 of?
My lord,
Fair,
yes, right to fair compensation.
Right to fair compensation. Right to fair compensation. Says- Right to fair compensation.
Page 59, section 64.
Right, section?
64, my lord.
Yes.
Reference to authority, any person interested who has not accepted the award may by written application to the collector required that the matter be referred to the collector for the determination of the authority as the case may be, whether his objection to the measurement of land, the amount of compensation, the person to whom it is payable, the right of rehabilitation and resettlement, and chapter 5 and 6 of or the apportionment of the compensation among the person interested, provided that the collector said within a period of 30 days from the date of receipt of application, make a reference to the appropriate authority. Provided further that where the collector fails to make such reference within the period so specified, the applicant may apply to the authority as the case may be, requesting it to the direct the collector to make the reference to it within a period of 30 days. The application shall state the ground on which the objection to the award is taken. Now, provided that every such application shall be made, person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of his collector's award. In other case, within 6 weeks of the receipt of the notice from the collector under section 21 or within 6 months from the date of the collector's award, whichever period shall first expire. Provide further that the collector may entertain an application after the expiry of the said period within the further period of 1 year if he is satisfied that there was sufficient cause or for not filing it within the period of specified in the first provision. Now, section 65 again, my lord. Collector statement to authority. In making the reference to the collector shall state for the information of the authority in writing under this hand, the situation and extent of the land with particulars of any tree, building, standing props thereon, the names of the person, these are the conditions that has to be complied with. Now, Lordship, if we look into my lord application, my lord, simply once it has been submitted, the award was pronounced on 9/2/2022. The application was presented by the parties concerned on 18/8/2020, which is time barred. No explanation in their application about delay. Now, thereafter, my lord, this application has to be referred to the authority concerned within 30 days by the district collector. But this was referred on 28/11/2023, my lord. Lordship, kindly see that in this situation, my lord, the Lords of Judgment says that the limitation is, my lord, very important crucial issue, because, my lord, the project has been designed with certain cost support. If suppose somebody come at any point of time, my lord, definitely affect the project, my lord, because, my lord, again, suppose a reassessment or whatever, my lord, in indefinite period it will be allowed, my lord. My lord, it become very difficult for the government to, my lord, initiate any project, my lord. Second aspect, Lordship, kindly see that 60, the object of section 64 is just to, my lord, look into that the entire thing has to be done within a time frame program, my lord. There is a case where nothing has been done, my lord. Lordship, at this moment, kindly see that this is the legal questions which require to be dealt with, my lord, that whether 64 has to be complied with or not, my lord, or whether, my lord, what are the consequences of non-compliance of section 64, either by the parties concerned, my lord. This legal issue, my lord, now, my lord, subsists in this case, my lord. Now, proceedings pending, my lord, I pray this, my lord, if suppose first phase, my lord, was in my favor, my lord, the second phase, nothing to do, my lord. I pray, my lord, this moment, my lord, that proceeding which is pending may be stayed, my lord. One judgment, just I would like to place the procedure law.
Citation to what? Summary, citation to what? Citation.
Oh. My lord, top, my lord, head notes indicates the main legal point established in the judgment is that the collector must consider the period of limitation and reason for delay before rejecting an application for condonation of delay in filing for compulsion under the Land Acquisition Act. Acceptance or rejection, but, my lord, treatment must be given, my lord. It cannot be bypassed, my lord. It's a very casual approach, my lord. Somebody submit, my lord, it has been referred, my lord. Therefore, it's a purely case of non-application
No,
of mine.
after reference, what happens?
But now proceedings pending, we have been, my lord, called for, my lord,
You take, what you call,
next date is 30 for filing written statement, my lord. And this process is going on, my lord. That has to be, my lord, the action must be passed by this honorable court. And another case, my lord, I would like to place here same.
Normally citation to form with it.
My lord, same statement, my lord. There are lots of, my lord, similar situations. It affects the project, my lord. Main purpose is that, after getting this delay of, my lord, entertaining this kind of application without looking into the aspect of, my lord, section 64. And even, my lord, section 65
Where is-
demands certain
where-
condition to
where
be
is the-
complied by the
where-
collector. Nothing, my lord.
Oh,
No statement, just,
where is the determination, first determination of
my
the
lord, that
acquisition?
contained in, my lord, page. My lord, the wholesome determination is in page 35.
35, the original determination.
Yes, my lord. And column number 6, 9/2/2022 is the date of award. The detail of the party's name includes in thereafter page 636, my lord.
Where is the award?
My lord, award in page 35. That is the wholesome award of the entire land that we have, my lord, obtained. And the party's name is in the next schedule, page 36, column 7070.
What is the date of this award? You're not getting
My
it.
lord, yes, my lord, the award, my lord, column 6, my lord.
Column 6.
Yes, my lord, 9/2/2022. And my lord, that,
No, not 9.
my lord,
9 to 22 is the compensation, what do you call,
yes, my lord.
calculation.
It-
That is not the date of
My lord,
award.
exactly, my lord, this form we have only obtained, my lord. And there is no signature downward, my lord. That clarification is given, my lord, if required, my lord. Lordship, it's their application, my lord, of reference, page 18. There is no single whisper, my lord, that when they have
Not
received this,
if the document itself doesn't inspire confidence of when it was passed.
my lord. But actually, we have received only this much of copy, my lord. My lord, their own pleadings accepted, my lord. Kindly see paragraph 1, page 20. That confirms. The date of 9/2/2022. Page 20, paragraph 1.
Paragraph 1 is about gazette notification,
Exactly.
not the award.
That the gazette notice come after award.
Just give me the dates again. When was the award?
My lord, award pronounced on 9 February 2022.
Yes.
Reference application was made
No,
on
when is the gazette notification of acquisition?
9 February 2020, page 30.
Is 13.
30, my lord. Page 30, 30.
30.
On, my lord, middle part is written 9 February 2022. Application was submitted by the parties
No, then
concerned.
something is wrong.
But
Something is wrong. Right to pay compensation. Oh, sure. No, you show us in sequence. You see, we'll not be understanding this.
Right.
Number one, for the purpose of acquisition of land under this Act, 2013 Act, first of all, you have to have a social
My lord,
Uh,
assessment.
impact assessment. Then you will be paying the compensation. And thereafter, this notification will be issued. So please complete that sequence.
My lord, sequence is that my section 20,
Because
lord,
you see, you will also have to give notice.
21, my lord, section.
Well, sections I won't remember so easily. For objections, if any.
My lord, my lord.
And then will come the notification. So the date of the award, if it is 9/2,
Right.
notification is 9/2. That means there's a lapse in the what do you call certain procedures.
Proceeding, yes.
Because I may also issue, unless you satisfy us, we may also issue why this we can also question the entire process of the acquisition.
Right.
This because in this gazette notification, this social impact assessment is not referred to.
Right.
So that goes to the root of the matter. Even in your petition, we may
My lord.
question that.
Lordship, since the pre-exercise of my lord, that contemplate regarding a pronouncement award, my lord.
You will
Hello,
be having
sir.
the documents.
Yes.
You will be having the documents.
Right.
Because once you, the intention of the government to acquire,
My lord,
then these procedures,
Right.
that you will have to demonstrate.
my lord, quite right.
You'll fix it day after tomorrow or Friday.
My lord, Thursday, my
Thursday is a
Friday.
hearing day, either Friday or Wednesday.
Friday.
Friday. If you have also those documents to please produce before us.
My lord, government may have,
No. This because you will get a notice for before acquisition.
my lord.
You must be having it.
My lord, I am for the High Court, my lord.
Oh, I'm sorry.
My lord.
I'm sorry.
The private respondent, they are not here.
Okay. Why High Court has appeared here?
My lord, because the proceeding is pending, my lord, we have
The
thought,
court.
my lord.
We made
No,
party.
you can't make a
My
High Court
lord,
party.
I think, my lord, I have to strike down, my lord.
No,
Additional district judge.
no.
My lord, that has to be struck down. my lord.
But Mr. S. Chamadian will counsel for the petitioner. So at the as well as Mr. S. Barwal and government advocate appearing for respondent number 1.
Thank you, judgment to the.
And Mr. G. Bushel and it standing counsel for this court appearing for respondent number 2. Next one at the outset. The court is of the opinion that the Respondent number 2, I, the additional district and session judge. Kamrup with the bracket R. Says in jurisdiction and the judicial site is not amenable to the rate jurisdiction of this court. First off. The if one needs an authority in the matter. One may refer to the. Judgment of the Supreme Court of India in the case of decision is the 9-judge bench of the Supreme Court of India in the case of Naresh, NERESH, Sridhar, SHRIDHAR, Mirajkar, MIRAJKAR, and others versus State of Maharashtra and another, AR 1967 SC1, where it has been held that no writ can be issued upon a court. Therefore, on the pyramid by learned counsel for the petitioner, the name of respondent is struck off without disturbing the seriatim of the parties in the cost action. Next paragraph. The award, the copy of award which is annexed to this representation does not have a date. In view of the requirement of compliance of section 4 to 12 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013. Petitioner is directed to produce documents relating to the compliance of the provisions of section 4 to 12. No, 4 to 12, 4 to 13. 4 to 13 or the said 2013 Act. Next paragraph. In the meanwhile, the learned government advocate shall also make an endeavor to obtain the same from the office of the district collector, Kamrup Rural. Now. Next, list in the motion column 126. 4/2024.
Right.
You can send a downloaded copy of this order. Mr. Barwa, you send a downloaded copy of this order to the deputy collector, deputy collector.
Also, can it be fixed on Monday?
Monday.
Only thing about 30 is the next date there, my lord.
Huh?
30 is the next date there for my lord.
No, because of
30 is
this,
Tuesday.
Lot of.
My lord.
29th, okay.
My
Because he'll.
lord.
need-
He's asking for crossing manner in 226.
Yes, that is possible, my lord. There is no
No,
need.
I don't know, we are not pre-assessing it,
Oh, my-
but pre-assessment is not being done.
Yes,
The
but-
question is that
It's a matter of non-compliances of the duties, my lord, cast upon
So
the.
that this
See,
is
as a-
procedural part, man. Only procedural part.
he has a ground. Because
When substantive law and procedural part clash. My
no,
lord,
we don't know.
Yes,
We-
ma'am.
Cannot bypass, my lord.
So far
Procedure
as-
part can be
so far as
considered,
that
but
issue is
cannot be
concerned,
bypassed.
I think he has a ground. Because in NI also, the court has power to condone. In a complaint when it is otherwise bad. The court will have to
Exercise.
condone that delay.
Yes,
That part
that
has to be
power
done.
has to be exercised
Otherwise.
by application of mine.
My lord, one judgment I have found, my lord, where my lord, even section
It's okay,
5
we'll take it up on that
limitation
day.
will not apply, my lord.
Obliged.
If I start hearing now.
My-
then
Yes, ma'am.
there will be no question of adjournment. then.
He opened the card, my lord. My lord.
13,
Item 13.
Well, by this application, I am challenging the inclusion of the tea garden within the municipal area, my lord. The import management is not necessary, my lord, and the Plantation Labor Act, my
additional
lord.
notice. But Mr. G. N. Saivara, Senior Counsel, assisted them, say, A.K. Saivara, Counsel for the question. And Mr. N. Goswami, learned government advocate appearing for
1, 5 and 6.
respond numbers 1, 5 and 6. Will be for 2.
Notice to proceed.
uh, the inclusion of the tea garden area of
Tea of tea state
Tea of Tea Estate
within Sonari Municipal Board.
in the Sonari Municipal Board. Under municipal area of Sonari Municipal Board is disabled in this resolution filed under Article 226 of the Constitution of India. Issue notice. Issuing notice on the prayer for interim relief returnable on. You can serve notice by Dusty, Mr. Saivala.
My lord,
Can you serve notice by Dusty?
yes,
Hold on. P5 2024. Requisite extra copies of the writ petition be served on the government advocate in course of the day. Next paragraph. The petitioner shall take steps within 2 days for service of notice on respond number 2, 3, and 4. Yes. Sorry, 2, 3, 4, and 5. No. There can't be both. There cannot be an executive officer and the chairman both.
yes, my lord. 5 is not necessary, my lord.
No, if there is a chairman, then there will be no fights.
No, that may be stuck, my lord. 5 may be stuck. 5, 4,
Right.
5, 4, 5, both may be stuck.
No, 4 will be there, vice president, vice chairman.
Oh, vice chairman is,
5 has to be struck off.
yes, 5 may stuck.
You get instructions because if I strike it.
No, it is stuck, my lord. The executive officer cannot be there, my lord.
Okay.
Earlier it was there, but now it is not.
So this is 1, 3, and 4. By registered post with AD as well as by way of Dusty, by putting the process to the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph. As respondent numbers 3 and 4 are representing respondent number 2. The senior counsel for the petitioner is to strike out the name of respondent number 5. Here is allowed. The name of respondent number 5 is struck off without disturbing the seriatim of the parties in the cause title. Yes. Where is your notification?
Notification, my lord, page, my lord, that 34, my lord.
Okay, the um,
34, 35.
the respondent number 2 and 3, 2, 3 and 4 shall not enforce the notice of demand. Number, page 49, huh? Number so and so, dated 5/3/2024, till the next date of listing. Fourteen.
14.
Wait, please, sir.
Just on. Just- Sandeep, the advocate. Right? Look at this one. Yes, Mr. Sheikh.
My lord, land measuring 8 biga, 2 kathat, 18 lasas. My lord, was originally Akshona Patta land. And subsequently it was converted into Medi land. And thereafter, what happened, my lord, by 2 sale deeds,
Against the orders of the deputy commissioner,
my lord.
you can always go to Board of Revenue.
No, my lord, their problem is this, my lord. Now, in the land record, that order is not available. We approach, they are not supplying us this order of copy.
Where
Now, my lord,
is your statement that I did not get that statement?
my lord, my humble submission
No,
before.
where
your
is that
lordship.
statement? I missed it out. Where is that statement that you're not getting documents?
My lord, at this stage, my lord, I am not on that order of 2008 conversion. I have filed a representation. My prayer may be leaked into my lord.
Where is your prayer?
Representation may be disposed of, my lord.
Where is your prayer?
My lord, prayer at page 11.
No, you see, the correction of land records,
My lord.
it can't be corrected by way of representation. That will be something which is not prescribed.
My lord,
under the land-
I want that your lordship would be pleased to see my representation.
No, Mr.
The
Sheikh,
representation is this, my
Mr.
lord,
Sheikh,
matter may be
Mr.
inquired
Sheikh,
into.
no, Mr. Sheikh. More than representation, I'll be interested to know provisions in the Assam Land and Revenue Regulation when it can be corrected.
My lord.
If the act provides for the representation, we will permit it. But in land revenue matters, we will not permit something which is not there in the land acquisition, land revenue and regulation act.
My lord, thing is this, my lord, let me place my case. My case is this, my lord, I have purchased Patta land. That Patta land has been converted into Akshona Patta. And in the meantime, what happened, my lord? In 2021, 6 lakhs, some thousands, my lord, rupees taken from me for converting the land into commercial land. Now what happened, my lord? Recently we came to know in 2008, land was converted into Akshona Patta land. If that is so, in 2021, how the land is converted into commercial land by accepting amount, my lord, 6 lakhs and what, 79,000. My humble submission before your lordship, let the deputy commissioner inquire into the matter.
Where is that document about payment of money? Where is
Yes, my
that?
lord. First, your lordship would be pleased to see page 65.
65.
That is the order by the deputy commissioner.
Yes,
My lord, now your lordship would be turned to page 66.
66.
Yes, my lord. Premium I have deposited, my lord. 6,39,000.
Yes,
Now your lordship will turn to page 67.
yes,
Annexure 11. Class 3. commercial land, Zamabandi Coffee Mill. It is in 2022. Now, my lord, my humble submission before your lordship. In their representation, my only grievance is this deputy commissioner may inquire into the matter, how it has done. When in 2021, land is converted into commercial land by accepting 6,79,000 rupees from me, my lord. I want that may be inquired into how it has done. That is my simple prayer, my lord.
Where is the order of conversion of land into Miadi again?
My lord.
Where is that?
My lord, your lordship turn to page 16.
16.
16, 1/6. Remarks, my lord. By the order dated 23/12/2003, passed by the circle officer so and so, my lord. Now, my lord, last sentence. By the order dated 26/12/2003, passed by the circle officer, entered into Medipatta land being number 78. It is in the name of original Pattada, Gopal Chandra Pradhan. It was done in 2000.
No, I'm not on that. I'm asking you a question where it was made Miadi again. Sorry, annual patta again.
NL Patta, my lord. Yes, my lord. My lord, that order is not available with us.
I'll tell you why.
My lord.
That's why we are asking that
My
question.
lord. My lord.
2003, the land was mutated from an annual patta to it
Periodic
was
patta.
converted to a periodic patta.
Periodic Patta.
When it's converted into periodic patta, there is a ceiling for transfer.
My lord.
In violation of that ceiling, you have transferred the land to yourself in 2004. So that is a violation of the condition, and therefore the land was reverted back to the government. Now, if you want to have that transfer of the land, you should have taken permission from this state government. That having not been taken,
No, my lord, I'm the purchaser of the land, my lord.
that's why we are asking you.
My
You see, there's a reason for asking you this question and then telling you this story.
My lord.
So therefore, no representation. There can't be a representation in the land revenue cases. You withdraw this file on Board of Revenue.
My lord, regarding Board of Revenue, my lord, only problem I am facing. I was also, but thing is this, my lord, that land record, the order of 2000.
Oh, the Board of Revenue will bring it, don't worry.
2008, my lord. 2008 order is not available, and Revenue
The
Board is
land-
not accepting my appeal, my lord, without that certified copy.
It can't be.
My lord.
Because you see, incidentally, I have some experience in going to Board of Revenue.
My lord.
At the time of filing, the Board of Revenue never scrutinizes the contents of the petition and then accepts it.
My lord, I approach, my lord, but problem is this,
But you
without
see, I have
certified
that
copy, they are not
experience.
accepting, my lord.
I have had that experience.
My lord.
Many years I have spent there.
My lord.
Because in my case, I did not find the Board of Revenue scrutinizing a petition and finding out defect. It has never happened. You see, you are challenging an order. Board of Revenue will call for all the documents.
My lord, to that extent, my lord, I am not allowed to go.
Where is your statement? There is no statement to that effect. We can't accept.
My lord, I will file an additional affidavit regarding that, my lord. Statement
Give it
regarding
on
the
record.
statement.
You can don't record. Then we'll dispose it of allowing you to file your appeal, and the Board of Revenue will call for the records. But on an oral statement, I am not going to do it.
That finding may also may give in. All right.
Huh?
With that observation also, my lord, that may be disposed of. That I will approach the Revenue Board. my lord.
But Mr. M. A. Sheikh, counsel for the petitioner, and Mr. N. Goswami, and government official, appearing for the respondent numbers. All the respondents. No, sir, respondent 2 and 3, then one will be Mrs. P. R. Make it serially. Mrs. P. R. Any counsel for revenue department, appearing for respondent number 1, and Mr. N. Goswami, then government official, appearing for. Next. The petitioner projects that he is a owner of the land, which is referred to in Schedule B and C of this writ petition. Which is claimed to be a Pata land. And it is alleged that in the year 2008, the said land was reconverted into an annual Pata land. Full stop. Accordingly, for restoration of the status of the land, a representation dated 24/8/2022 has been filed by the petitioner before the District Commissioner, Tejpur. And therefore, this writ petition has been filed for a direction of the said respondent to dispose of the representation. Next paragraph. In the considered opinion of the court, orders passed for changing of the status of the land would be an appealable order within the meaning of section 147 of the Assam Land and Revenue Regulation from 1886. Stop. The reconversion of land by way of representation is not envisaged under the scheme of Assam Land and Revenue Regulation, 1886. Therefore, the court is inclined to close this writ petition by granting liberty to the petitioner to SL the said order in the manner provided under the Assam Land and Revenue Regulation, 1886. So with that, we said liberty, this petition stands closed. Just a moment. Going to close this. further liberty is granted to file an application for continuation of delay, comma, if any, in filing the appeal. All of it.
Item 16.
See, respondent number 3 file has an application for praying for in auditor vacating the interim order dated 22/2/2023 passed in WPC 930/23. At least at page.
Lord, they took time to file a rejoinder. They had filed a stay vacating or application. We brought on record certain documents stating that we are paying. They allege that we are not paying the profit share. So we filed an detailed affidavit.
No, this, who is the applicant in this IA?
Lord,
Mr. Bhagwati.
the respondent is there.
Lordship, stay was granted, height order dated 22/2/2023. It was an interim one. At page, since the interim order is primarily based on the ground of there being no audit, and the case of the petitioner is that such auditing was not done in spite of best efforts of the petitioner till returnable date, it is directed that no coercive actions steps should be taken against the petitioner. These civil matters. Actually, they have not paid us. There was an agreement in the year 2017. PPP model agreement, wherein we let out one, what is that, hotel to the petitioner. He was supposed to pay us 35/65 ratio. He did not pay any single penny till 2023. Only after filing this stay vacating
We
petition.
can't permit paying in pennies because that is a foreign currency.
Lord, sorry.
Penny is a foreign currency.
Lord, rupee.
In rupee. Okay.
Rupee. Rupee. Lordship, only in the year 2023, when we filed a modification petition, or is a stay vacating petition, thereafter they paid some amount from the February to August. So at least what the ground they have taken, that there was no audit as such, they were not able to pay us money. It is not a correct one, because by that itself, it is, they have, without being audited, they have been paying us from February to August 2023. Since then, August also, they have not paid us. So it is almost 5 years.
Suspension we can't entertain. You ask, if you want to argue, you argue the matter, otherwise you ask Mr. Deca to address us.
Yes, my lord, may kindly then pass over the matter, my lord. Please, my lord.
Okay, after some time.
Seventeen.
May please, Your Honor. My lord, this petitioner has been functioning as a president of the Jangarai Gaon Panchayat Samabhay Samiti Limited. By an order, AGM.
Panchayat will be meant for. Panchayat is meant for.
It's cooperative society, your lordship.
Oh, cooperative society.
What is Samabhay Samiti?
Yes.
Annual general meeting election of the society was held on 13/10/2017. But that election and AGM was disapproved by order dated 15/11/2017. Challenging that order, and writ petition was filed by the then president of the Gaon Panchayat, wherein this honorable court has granted interim order.
But this matter has already become infructuous.
Yes, my lord. I have completed my term. Yes, my lord.
Still holding the post of president, your lordship. The tenure is over.
Yes, I have no objection if the department proceed with the as per law and rules.
Mr. D. Kotoke, then I counsel for the petitioner. DK Kotoke, DK Kotoke, counsel for the petitioner. Mr. Next para, Mr. G. Borulai, learned Standing counsel for the Corporation Department. All the respondents, appearing for all the respondents, has submitted that the petitioner was functioning as the president of the Jengrai, Jengrai, Gaon Panchayat, Samavai Samiti Limited, since its AGM held on 13/10/2017.
Yes, madam.
Accordingly, it is submitted that the 5-year tenure of the petitioner is already expired. On the next paragraph, on the query of the court, the learned counsel for the petitioner has fairly submitted that the said position is correct. Next paragraph, as the tenure of the petitioner is already as president of the said Samavai Samiti has already expired. Notice of the considerable opinion that the matter has become infructuous. So according to this, the petition stands first. The interim order passed on 20/11/2019. Stands vacated.
Obliged.
18.
Lordship,
Yes,
Lordships, last order was passed on 16/2/2022, Your Lordship. And according to that order, we have served notices upon the respondents by AD, registered AD, and also by Dusty Services. But Your Lordship, there is a great mistake on my part, Your Lordship, that there, due to lack of communication, this affidavit was not filed, Your Lordship, regarding service of this, regarding this Dusty Service, Your Lordship.
that means JD counsel for the petitioner. It appears that this petition has been wrongly registered as this petition has been filed in Article 227 of the Constitution of India and
Yes.
the proceedings of the of title suit number 34 of 2018 has been assailed. You see, we are not only saying that this is wrongly registered, but we are we'll be dismissing the audit petition if there is a proceeding which is going on before a trial court.
Yes, Your Lordship.
You will have to file an appropriate application if the same subject matter of the suit is pending in this court at
RFA.
RFA.
Yes, Your Lordship.
We can't entertain applications for stay. It's just not what do you call it? This is an abuse of the process of court.
Parties are same, Your Lordship, and the subject matter is
No, in
also
CPC
same.
there are provisions. If there are two suits within the between the same parties,
Yes, Your Lordship.
you have to just search for the answer in the CPC. Writ petition is not maintainable.
The RFA is pending, your lordship, on the same
It
subject.
may be pending, there may be 10 suits pending. So will the High Court take up in writ petition proceedings before the trial court and say which proceeding will operate and which will not operate?
If that trial court proceeding is allowed, your lordship, any judgment is passed,
You
then
take your call. You please read the CPC, you will find an answer. The court is not there to suggest you what is to be done. But this application is misapplied.
otherwise, your lordship, the RFA will be infraction to us, your lordship.
We don't know about that. There's an appropriate application under the CPC, you file it.
Okay.
If you don't know, you may ask someone who knows where to find that answer. Be that as it may, it is noticed that the grievance of the petitioner is that between the same parties, a proceeding in form of RFA 1 of 2015 is pending for adjudication before this court. Which arises out of judgment and decree dated 15/3 to 2014 passed by the learned civil judge Tejpur in TS 3 of 2009. First of the said suit was for declaration of lawful possession of the plaintiff, namely Rishi HRISHI Bardhan BARDHAN Bordoloi, and for permanent injunction. Full stop. The next, the defendant number 1 in the said TS 3 of 2009, namely Anima Mahanta, ANIMA MAHANTA, has filed a suit before the court of Munsif at Tejpur, which is registered as TS number 34 of 2018 for recovery of possession and recovery of rent against the plaintiff in TS 3 of 2009, namely Rishi Bardhan Bordoloi. Next, accordingly, by filing this writ petition under Article 227 of the Constitution of India, the petitioner has made a prayer in this writ petition for stay of the proceedings of TS number 34 of 2018 till disposal of RFA 1 of 2015. Next paragraph. In the considered opinion of the court, this writ petition is misconceived, as there are appropriate provisions in the Code of Civil Procedure Code for stay of subsequent suits and proceedings. The said jurisdiction of the trial court cannot be usurped by this court in exercise of jurisdiction under Article 227 of the Constitution of India. Therefore, comma, is notwithstanding that this writ petition is wrongly registered. With this application under Article 227 of the Constitution of India is wrongly registered as a writ petition. But on merit, this application is not found to be maintainable, and therefore this writ petition stands closed with liberty to the petitioner to move an appropriate application for the jurisdictional court. Accordingly, this writ petition is also closed. Thanks. They can come back. Complex.
Twenty-one. There is no representation from both sides. For kinds of justice in matter stands adjourned today. This after 2 weeks. It is made clear that if the petitioner remains unrepresented on the next date, appropriate. Shall not appropriate. It will follow. Twenty-two.
Is it alive?
No problem. In my opinion, it's not here because we have changed the policy decision, Lordship. Rather for going for tender, we went for departmental, Your Lordship, on this forestation.
The afforestation program.
Yes, Your Lordship.
But there's no representation from the petitioner. Mr. R. Goel and standing counsel for the Forest Department submits that as per his instructions, the matter has become infructuous as instead of afforestation work through tender process, the work is now being done departmentally.
Department, Lordship.
You're also there? No. For answer justice, the matter stands adjourned today. There's no clear that if the petitioner remains unrepresented on the next date of listing, adverse orders can follow. List after 2 weeks.
Obliged, Lord.
Item 23.
In this case, I have filed my affidavit, Lordship.
Yes. It was filed long back.
Yes.
Yes. 34. Yes.
On
It
behalf
was for
of
2
A.
weeks.
Dasgupta.
It stands adjourned for 2 weeks. Okay, all sides are represented on the prayer made by counsel for the petitioner. The matter stands adjourned today. List after 2 weeks.
Yes, sir.
Twenty-five.
This case also, Lordship, we have not received an instruction, Lord.
Just one. Then we allow the writ petitions on the ex gratia. You're not denying the accident.
Is the examiner.
But is there any statement here that no MSCT case has been filed?
No.
Is there any statement?
No.
No. Okay. None appears on call for the petitioner. However, Mr. N. Goswami and government advocate and Mr. A. Bhattacharya and counsel for respondent number 1. For the revenue department, respondent number 1 is present. Next paragraph. It is noted that the petitioner claims to have been, the petitioner claims that his mother was hit by a tractor bearing registration number AS 17C 0335. Pursuant to which she had expired, and Golabganj PS case number 193 of 2019 was filed. Therefore, this is not a case of hit and run. And as the vehicle is identified, there would be no bar for the petitioner to make a claim before the Motor Accident Claims Tribunal. Next, therefore, in view of the aforesaid prima facie opinion, the learned government advocate shall address the court on that aspect of the matter of the next date of listing. Next paragraph is further made clear that if the petitioner remains absent on the next date, listing, adverse orders may follow. You be prepared on that day. Sorry, madam. You are there. Yes, then you say about maintainability. How would this be maintainable? Your vehicle is identified. No, we are seeking only the ex gratia matter. Ex gratia matter. You not get. The vehicle is identified.
Yes, madam.
So therefore, you file a MSCT case.
But that notification will affect for my lord later
No,
on.
not
but
every
this-
case.
This incident took place earlier, my lord. This incident took place earlier.
Whenever it takes place, you have to file a MSCT case. You have not given any statement that no MSCT case has been filed. You can't approach two authorities.
Yeah, there is a notification, my lord, but that notification will come effect from the date of issue, my lord. The cases, incident took place earlier, my lord, that will not covered by this notification, my lord. I will place on the next day. my
No,
lord.
it's not a question of notification. Where is the bar in approaching the MSCT court for compensation?
That will get, my lord. That will get, my lord, they will get that.
Then this situation will not be maintainable. You can't get two compensation.
Others are getting, my lord.
It can't, there's a, you address us of that.
Many number of cases, my lord, they have paid, my lord.
But it doesn't appear to be correct. If you get that, then MSCT award will be, you'll not get it.
But as per notification, my lord, 15, 11, 14, there was no bar there. If you get,
No, exhibition means that you are not getting any compensation and therefore government is giving you a helping hand. When you are collecting a compensation from the MSCT, then you are not required to be given a helping hand.
but my government also paying, my lord, in
No,
all
you
cases,
can't.
my lord.
You call your revenue secretary and then have a conversation with him. The address of.
In all cases, they are paying, my lord. Now they issued a notification, my lord, saying that those vehicle identified, my lord, they will not give.
No, even after.
In recently, my lord. But earlier, all cases are there giving, my lord.
You can't get it.
The date may be fixed, my lord.
Your address is on, your address is on this issue.
That's it.
The presence of Mr. HR Ahmed for the petitioner, HR Ali,
Yes, sir, Ahmed.
HR Ahmed for the petitioner. Same order. That is on list on. After 2 weeks, the date.
My lord.
Come to all matters.
13th May, 13 May.
Obliged, my lord.
Item 26.
My lord, the vehicle of the petitioner is a commercial vehicle, my lord. It was detained in violation of Custom Act, my lord. But this morning, my lord, Standing Council, Custom, my lord, he transmitted me some order has been passed in my WhatsApp, my lord. I could not get it loaded down, my lord. So may I pray, my lord, let me go through that order, my lord, what has passed. So,
What
lord,
has happened?
Chief, he's on Lexington court number
No, no,
1.
what has happened?
he has given me, my lord.
So he's given.
He has given me in my mobile. Any day next week, my lord, we'll see, my lord, whether appeal lies or what to do, my lord.
Okay. Both sides are represented. The,
Only one thing, my lord. My lord, today, my lord, Standing Council communicated, my lord, that
it's okay.
be reflected in the order, my lord, question of limitation is there.
The standing counsel for the respondents has forwarded a copy of the order passed in this matter to the by WhatsApp to the learned counsel for the petitioners.
Today, my lord.
They, so accordingly, accordingly to the learned counsel of the petitioner, pays for some time to go through it and take appropriate instructions. List. Give a date after 2 weeks.
13/5.
13/5.
March 11.
28.
Item 28.
I, along with my private respondent number 9, your lordship, had a partnership firm in the name and style of Messrs. Wood Enterprise, your lordship. Lordship, there is an agreement between the between my partnership firm and the APDCL.
No, you see, this dispute will have to settle it amongst yourselves. Go to a civil court because rate court will not say to the APDCL whom to pay, whom not to pay. If we take up these matters, then there is no utility of a civil court. All disputes will decide here. We don't need CGM court. We don't need magistrates court. We don't need
this court, we don't even need deputy commissioner's court. We decide everything.
I'll leave to you, Lordship.
This has to be closed. You go to a civil court.
That's
Private agreement cannot be adjudicated in this writ petition. Partnership. Partnership Act. Mr. Baru, there are two ways to go about it. I'm asking you because to enable you to take a call. You see, this is a registered part, there is a partnership which is registered. But I don't find anything here which says that your partnership has been registered under the firms and register of firms and societies.
Right.
So that goes to the root of the matter. If I make any adverse observation, it will harm you.
Yes.
Can I just say that you, at your prayer, we allow you to withdraw the writ petition to go to civil court?
That's it.
Okay. Mr. R. Borun and counsel for the petitioner, and Mr. K. P. Patel and Mr. Nikos for the APTC. Next problem. After some deliberations, the learned counsel for the petitioner seeks to withdraw this writ petition and to oppose the civil court. This prayer is allowed, the matter stands closed with liberty as prayed.
Item 29 with 30.
May I please, Lordship? In this matter, instruction is awaited, Lordship. Some
It's
more
not
time.
come. Last time we told you.
Yes, Lordship, and concerned advocate BJ Talukdar, sir, also
Because
hospitalized.
it will never come. Because you see, first of all, you must have a plan.
Well, one more problem is Mr. Talukdar, he is hospitalized.
Hospitalized.
Oh, is it?
Yes.
Oh, no, I'm sorry. I'm sorry. But still, Mrs. Bada, please try to understand. In these cases,
Yes,
you must have a plan.
yes.
The government must have a plan. Part of the land is non-cadastral. So I have limited experience in non-cadastral areas. So we suggested on the last occasion, I think there's a.
In the order
also.
Yes,
You see, unless you go with the GPS, what you call?
Coordinates.
Coordinates, and then mark it and then go, you will not be able to demarcate. Last time we got an impression that your officers are trying to get the help of Director Land Revenue, Director Land Records, which means that you will be doing theodolite, what is it? What's the word?
Old
System, theodolite.
Conventional method.
Conventional method that doesn't apply in a cadastrally mapped area.
yes.
So that's why we told you that please tell us what is happening. You see, there are two interests. Number one is the interest of the state. That is paramount because you say that it's a tribal land.
Yes.
We accept it. Second is then there's a running industry. So we'll have to balance between the two.
1,600 employee minor, 800, direct and indirect.
No, whatever be, but that is the second interest. We have to take care of that also.
It's a question of balancing both the rights.
Yes. Okay, on the matter then, if he's hospitalized, but what has happened to him is
I think, my lord, he had some high pressure.
he agreed to a date.
After 2 weeks, Lordship.
He agreed to a date.
My lord, could it be any date after 7th of May, my lord?
So is a date will fix it.
Okay, okay. Into elections happening.
We'll accommodate whenever you
Okay,
want.
okay, my lord.
But take it in on motion day.
My
It's
lord.
easier for us to concentrate
It
on.
can be on the 13th or 20, my lord.
Uh, we can accommodate both. You
My
just take your choice.
20 May, Lordship.
20. 20, my lord.
Heard, Mr. Ken Chaudhary, Senior Counsel, assisted by Mr. Ajay Das, Counsel for the petitioner. First, Mr. A. Bhattacharya, Counsel for respondent number 1, for Revenue Department. And
For respondent number 5.
and Sarkar, Learned Counsel for respondent number 5, present.
I am for
Ms. S.G. Barwa, Learned. S. Barwa,
S. Borwa,
Learned Government Advocate.
Government Advocate.
Case for an adjournment on the ground that Mr. B.J. Taluga, Senior Counsel, leading her, is hospitalized. Post-op. In view of the said reason, the court is inclined to adjourn the matter today. As agreed to by both sides, based on 2/05/2024. But Ms. Barwa, you please write it down. We must show us a plan. Because unless there is a clarity on what we want, you are the revenue officer. You must tell us how to proceed. And this is other way around. We are suggesting who is not a able.
In fact,
not an experienced person to tell you.
Lordship
what to do.
order has indicated which course of action is to be adopted.
No, Mr. Chaudhary, it's okay. At times we make certain observations in the order, but ultimately in this revenue mapping, I am a layman.
Of course, end of the day, it is the
And
expert who
they
will have
will
to
have
do
to
the
tell
work.
us how to do it. But please tell us, how do you want to proceed? If required, you call an officer who will explain it to us how it is to be proceeded with. Because we have rough ideas. And then some education comes from internet. So that makes the things mess. Correct?
Yes.
Please convey it to them.
Deeply.
Otherwise, 22 to 24, 2 years have gone by.
Yes, yes.
Uncertainty, their industry has to run.
Yes.
That is one of the interests, along with your interest,
Yes.
to protect the travel areas.
Deeply.
Okay.
And Mr. Chaudhary, just one more thing. We take an adverse
View.
view. Supposing this land is otherwise found out to be ultimately a tribal land.
My lord, in
Then-
fact, each and every deed, my lord, which we purchased, it was pursuant to the permission given by the district magistrate.
No, that's okay.
Yes.
We are taking of that because every time the objection is raised on the ground that the deeds are, Mr. Anil Chaudhary, the submissions. He was insisting that the deeds are fraudulent and not found. Now, there's another aspect which.
7 out of the 20.
So both of you will also address us on the various notifications under chapter 10.
Okay.
Because in revenue circulars, I don't have the collection now. Earlier, there were general circulars where this notification is issued from time
My
to
lord,
time.
end of the day, the call lies with the state government under 163(4). State government for the purpose of industrial, they can, my lord.
No,
My
I'm
lord,
not on that.
my lord,
I'm not on that.
Okay.
What I'm trying to say is that there are various notifications under chapter 10.
10.
That the government will have to make a compilation and give one set to Mr. Chaudhary also, so that when we take up the matter ultimately, we can address those matters, because I
Yes,
don't have the collection of
Okay.
revenue circulars issued under
Chapter
chapter 10. From time to time, they are issuing it.
we'll also try to find it out.
They will get it. Because since she's from revenue, she will get it. For revenue, Mr. Bhattacharya, get those collections of, and spare a copy to Mr. Chaudhary also, so that that can be adjusted for the next date.
Deep drill.
31, 32.
Item 31 with 32.
May pleasure, Lordship.
Yes.
Lordship, in this matter, violation of order dated 4/1/2023, my lord. My lord, that is page number 20, my lord. My lord,
Okay.
paragraph 7, last person, my lord, respondent authorities from the disposing, my lord. Disposing instead of dispossessing, my lord. I have a correction order copy, my lord.
You file by affidavit because this is contempt matters. We can't take up documents like that and pass orders. You have to give it on. Let us see. Have you annexed that? No. Just give it to the court master. Okay, yes. Yes, you have filed your affidavit. Who is appearing for the respondents?
I will be appearing for respondent number 2 and 4, but I am not confirmed whether notice has been issued or not.
Notice has not been issued.
Yes, ma'am.
Okay, your name?
R.I. Bhuya, my lord.
RM?
R.I. Bhuya.
R.I. Bhuya, counsel for the petitioner. Issue notice on this. Contempt petition filed on Article 215, read with of the Constitution of India, read with Section 12 of the Contempt of Courts Act for violation of order dated 4/1/2023, passed in WBC 8416 of 2022. Next issue. The notice is made returnable on. Give a date after 4 weeks. Next, the petitioner shall take steps for service of notice on the respondents by registered post with AD. Especially in 2 days, for service of notice. The notice is made returnable on so and so, based on the set date.
29/5.
This should be already in contempt. This writ petition. In this writ petition, what has happened? You have filed your affidavit? No.
No, Lordship, we have not filed our affidavit, Lordship. We have sought for some instructions, Lordship. May I pray for 3 weeks' time? In the meantime, we will file our affidavit. Lordship.
Okay. Also, it's a represented, Mr. R.M. Das, learned counsel for respondent number 2 and 4.
No, Lordship, 3 and 5.
3 and 5. I thought 3 and 5. Standing counsel for respondent number 3 and 5. Praise for is granted 3 weeks time to file affidavit in opposition to the matter. Next further list on so and so. Same date.
Lordship. Declare.
Obviously.
Item 33.
These are Lordship, my lord. Some time may be granted to file affidavit in reply, my lord.
There was a preliminary issue framed here of maintainability.
They file an affidavit, my lord, some time may be granted. I'll reply.
Because this is a government land.
Can you see the annexures, my lord?
Which annexure?
Annexures 1, similar, my lord, all are similar, my
My
lord,
lord.
that particular one, my lord. May I read, my lord? নিম্ন তফসিলত বৰ্ণিত মতে অসম চৰকাৰৰ চৰকাৰী মাটি আপোনালোকক হিপিঠিত লিখা চত্বত দখলভোগ কৰিবলৈ দিয়া হয়. The next phase is not annexed, my lord. That is necessary, my lord.
Lord,
There may be some condition, my lord.
Mr. Barwa, then we dismiss this writ petition only on that ground.
no, Lord, can you be also after some time, my lord? My senior level, my lord.
Okay, after some time.
After some time.
But, if you don't file all the documents, then we are dismissing it in limine.
Not sometime now.
After some time. Thirty-four.
Sir, I pray for further 1 week time to have the inspection. But why the amount is not been paid? From the principal, I've got the instruction, they have submitted, and the proposal was submitted. So thereafter, whatever is the outcome is not there, I've updated instruction.
Okay, how much time?
Let it be after 10 days, this I can have the instruction.
And Mr. R. Dubey, counsel for the petitioner. Mr. B. Govil, and a standing counsel for the health department, raised for and is granted 2 weeks time to obtain instructions about the status of payment. That's my list on, give a date after 2 weeks.
6,000. Well, almost.
36.
Sorry, can be a date earlier or later, 6th, I have some.
10th?
Yes.
10th of item 36.
Matter is related to excessive benefit or
No, there's here also say there's a motorcycle which is identified. You have to address us on maintainability.
Yes.
You have not mentioned here that you have not approached the what do you call the MSCT court, MSCT tribunal. There's no statement here.
MSCT claim has been continued. MSCT claim has been continued.
Has been filed. Then you can't have to, this compensation. You address us on maintainability. Mr. Saikia? You address us on the maintainability. You can't get compensation ex gratia when you have already filed a MSCT case.
Yes, Lordship. But Lordship, I am claiming on basis of the earlier notification, 15/11/2014, Lordship. And subsequently, Lordship,
No, once
notification
there
has
is
been passed.
once there is a MSCT claim made, you can't have ex gratia.
Same has been pending, Lordship, still pending. Before that
But
time.
ex gratia you will not get.
But Lordship, on basis of this present notification, Lordship, I am claiming, Lordship. The subsequently notification has been passed, Lordship, wherein clearly
No, it
mentioned
can't.
that
Once you have-
two
once
claim
you have
cannot
filed
be
this, you
applicable.
see, you are withholding facts here. You have not stated that which MSCT case you have filed.
But Lordship, until and unless the revoke of this present notification, Lordship, it is then the scrutiny of law, Lordship. What is the bar, Lordship?
There's a bar because you have already approached the for compensation. You can't get two compensations. It will be unjust enrichment.
But Lordship, the notification itself says that, Lordship. Herein, Lordship, nowhere mentioned that, Lordship, the person concerned who claimed that MSCT claim, he cannot entitled to get such benefit. For which,
We'll
Lordship,
interpret
what
that.
is the bar, Lordship?
We'll interpret that. It can't happen. The state will not pay when you're getting a MSCT claim.
But then, Lordship, the state itself revoked this notification until and unless it has been set aside and was.
We will
Or
interpret
rather,
that.
revoke, Lordship, this
We'll
notification.
interpret that. That's why we are asking you to make your
The
submission.
scrutiny of law, Lordship. On basis
That's
of
why,
this law,
sir,
this
Mr.
Lordship,
Saikia,
we are
that's why we
claiming.
are asking you to make your submissions.
Lordship, present notification itself says, Lordship, two claim cannot be applicable. I admit, Lordship. So, Lordship, my husband died in the year of 2020, Lordship.
Yes.
And prior this notification, Lordship, prior the present notification, now I am claiming the earlier notification 15th of November 2014, Lordship. On basis of that, Lordship, I am claiming.
You see, you complete your submissions because I have told you, you have not disclosed about the MSCT case here. So make your submissions, then we'll pass orders.
Yes.
We'll have to interpret that.
Yes, Lordship. That is my duty bound. I will file additional claim stating the present status of MSCT. This is my duty bound. I am it.
Okay, so Mr. M. Saikia, counsel for the petitioner, undertakes to file an additional affidavit to bring on record the claim petition from IFNI filed before the Motor Accident Claims Tribunal. This is further and government advocate and stay but a charger standing counsel for the Revenue Department. You speak to your Revenue Secretary and address us. This is a point we'll be requiring your assistance. List after 2 weeks.
No. Simply obliged.
37.
May I please, your Lordship? Lordship, may kindly peruse the last order, Lordship. The respondent was supposed to file a counter affidavit. That has not been filed, Lordship.
What is the civil suit? Where is that civil suit? Where is the documents regarding civil suit? You have a copy of the plaint?
They have not annexed the copy of the title suit.
What is there? You have a copy?
I have not copy at present. That may. No, I have no copy.
Yes, Ahmed, please ask Mr. Ghosh to come and address us. The privacy, we don't find this writ petition to be maintainable, despite the previous order of this court asking the parties to approach the Silchar Municipal Board and to have objections raised with regard to the consolidation proceedings.
Lordship.
Still, we are of the opinion that this writ petition would not be maintainable. Please ask Mr. Ghosh to address us.
Lordship, then kindly the matter may be taken up at 2, Lordship.
Okay. The reason is simple. You can tell him the query of the court. You see, what has happened, the plaint of the suit is not available.
Lordship.
But there is some statement, stray statement made somewhere that the suit is for declaration of 1/4 right title interest in respect of the said land.
Lordship.
Now, let us take an example. You two are brothers and sisters. There's a plot of land in which you have filed a suit declaring 50% of the land to be in your share. Now, can the municipal corporation pass any order of consolidation?
Till the decision of the civil court.
Can it be done? And to overcome that, you approach this court, get an order from this court saying that the objection be disposed of. Now, this order itself is non-compliable. Once there is a suit pending declaration of right title interest, there are decisions of this court by single bench as well as division bench, which says that once it's in connection with Board of Revenue matters, where this court has held that once question of right title interest is raised,
It's raised.
then other proceedings must stay. So therefore, Board of Revenue would not have power when question of right title interest is raised. There is not one decision, there are many decisions of the single bench as well as division bench. So because of that, once somebody claims right title interest in respect of 1/4 of the property, in my example, two of you, 50%, can a consolidation proceedings be taken up by the Guwahati Municipal Corporation? That is the only question, and therefore that is the only aspect you'll have to address. You also be prepared on the BMC, what you call municipal act after 2.
Time being item 33.
In this case, madam, they have filed an affidavit, madam. Well, I want to
Once-
give a
no, no,
different
no,
matter. I have received instruction.
No. Once your writ petition, the document is incomplete. Annexure 1, Annexure 2, those are incomplete. We'll dismiss it on that ground.
Well, I have received the document, my lord. I have received the
No,
document, my lord.
Once you see, once the government points out that this document is of, it connects, it has a back page. And that page you have conveniently withheld.
This document is in my favor, my lord. I am not to withhold, my lord.
But you see the document, look at Annexure 1. It says in the back page, there's a conditions given. Even in your translated copy, you use the word schedule. In the SMS version, is it PPT lekha? That means back page.
My lord, kindly give me a chance, my lord, to cure these things, my lord. It is there, my lord. My lord, for
No,
this, my lord, my
those are
petition
not
may not,
permitted.
may not be
Once-
dismissed, my lord.
No. Once you see, there's a document which is incomplete. And if we give an encouragement to cure the defect,
Well,
But at
whatever,
any time,
well,
anytime
whatever my
petitioner
client
can
is,
come and then say that, well, I missed that document,
well,
I-
whatever document my client has given, I have NS, my lord. Since they have raised an objection, my lord, I am curing it, my lord. Now kindly give me a chance, my lord.
you file a fresh writ petition, but this will not be entertained. Once there's a misrepresentation in the document.
It's going to be unable. It must be.
You withdraw this and file it again. We'll give you liberty to file again.
Next question idea, so there may some conditions.
You close it, we'll give you liberty to file again. But document which is incomplete and incorrect, it can't be accepted.
Well, I shall file a fresh, my lord, filing an affidavit, my lord.
You withdraw it and then file it again. But then you see, there's another thing, if a document is incomplete, and if the court arrives at a finding that it has been withheld, Supreme Court has said that it is also contemptuous. So if it is incomplete, you withdraw it. We permit you to file again. We'll give you liberty. We are not closing it. But Mr. KK, they counsel for the petitioners. This PM also done it. Government advocate has
Well, I am for one, my revenue department.
for Revenue Department and Ms. S. Barwal and the government advocate points out that the documents annexed to this writ petition as annexure 1 to 9 are incomplete as the conditions on which the allotment was made is not annexed. Next, the learned counsel for the petitioner seeks some time to rectify the defect. Next, as especially the documents are incomplete, the opportunity of rectification is will not be appropriate. Next, nonetheless, in view of the submissions made by the learned counsel for the petitioner, the petitioner is permitted to withdraw this writ petition and to approach again. To stop with the said liberty to approach the court again. This writ petition stands closed.
Item 39.
Your lordship. Well, this is regarding that, bank account was not.
Oh, yes.
Allowed to be operated. On the last occasion, the bank has produced the mandate. And I think that is on record. The bank lawyer has also given me a copy of that.
Where is that?
May I provide my copy?
I perhaps have missed it.
May I provide the copy that has been provided to me?
Well, please give it. I perhaps missed it.
So according to this mandate,
just. Any two.
Any two.
Yes.
Well,
Just a moment. Let Mr. Chaudhary complete.
Well, before the just 1 minute, Malad, I'm told that Mr. Counsel for the bank, Malad, he's stuck in CAT. So is that possible to take up this matter in 2 months?
Okay. Yes, Mr. Chaudhary.
I'll leave to your worship.
At two, then. Okay. This unfortunately was not here in the file because I tried to find out in the morning.
Well, I'll take it and get photo of it
It's
because
okay.
my learned friend also doesn't have a copy of it.
Okay, okay.
So look, affidavit has also been filed.
I use those affidavits are here, but
Yes,
this
sir.
mandate I was not getting. At times we have to, what do you call? Raise ourselves to many facets of knowledge. How an account is operated, that also.
Yes, my lord. In fact, had your lordship not been a little, my lord, stern, this would not have come, my lord. They were taking the plea that it is somewhere in Lokhara and account opened in 2015. So these are a plea being raised.
Mr. Daniel.
My lord, I have.
Okay. Yes.
Therefore, my lord, since any two persons can operate the account, and that is the mandate, my lord, the three persons have given, my lord, the bank could not have, my lord, withhold my lord, operation of the bank account by two partners. Therefore, my prayer would be your worship will allow the petition. So far as my lord, the grounds taken by the private respondent in this affidavit, those are, my lord, making some statements. But on that basis, my lord, the bank cannot stop the operation of the account, and if the private respondent has, my lord, any grievance, his remedy lies before the civil court.
Okay.
Admittedly, there is some dispute. And for that, my lord, the petitioners have already approached the civil court for rendition of accounts. There, my lord, they have appeared and filed their written statement. The matter is being examined by the civil court. And my lord, whatever dispute the partners of the firm inter se may have, that cannot be agitated in this writ petition. I am before your worship, praying that the bank, the three persons have given a mandate to the bank that any two persons can operate the account. And that is what they have produced also. Therefore, we should be allowed to operate the account and thereby, my lord, meet the liabilities, especially the statutory liabilities, salaries, and other liabilities. This is my limited submission.
Yes.
But this mandate form, my lord, this is for operation of the bank account. Any two of the three partners, my lord, they can operate. So there is absolutely no question, my lord. Certainly they can operate. Now, what is the present status of the farm? My lord? The farm has no life now. It is dissolved. By default, my lord, no operation could be done at this stage until and unless there is proper rendition of account is done. Now, they are coming up with a prayer, my lord, for statutory dues and all. Well, to that extent, my lord, even I do have liabilities. I have absolutely no objection to that. But how the quantum of statutory liabilities will be decided or fixed until and unless rendition of account is done. And more importantly, my lord, this partnership farm has no legal entity, my lord. It's like a joint account. My lord, if your lordship allow me, may I take your lordship to my affidavit, my lord? My affidavit, my lord, filed by the
Yes,
respondent.
yes, yes.
But that's
by all
very
means.
important, my lord, because
Yes.
my lord, paragraph 5. Yes, sir. Para 7 to be specific, my lord. Mary lordship. Paragraph 7,
Yes.
page 46. Well, that with regard to the statement made at paragraph 9, the deponent states that at the inception of the partnership firm, it was mutually agreed amongst the partners that till completion of the projects to be carried out, the capital contribution made by the partner shall not be withdrawn. Accordingly, after the completion of the project, the respective capital contributions have been withdrawn by all the partners, including the deponent. But it's true that, my lord, the projects that were taken up by the farm have already been concluded, my lord. After completion of the projects, my lord, the capital contribution made by the respective partners have been withdrawn. Even I too, my lord. There is no dispute at all. But it is indeed very disappointing episode to note that the other two partners, that is the petitioner number 1 and 2, have withdrawn substantial amount of money from the two numbers of bank account of the farm, namely so and so, so and so, so and so, in addition to their respective capital contribution, my lord, without any notice to the other partner of the farm, that is the deponent. And to be specific, my lord, even my lord, my client has issued in one legal notice, my lord. There too, two specific allegations, very serious allegation, my lord, raised by the respondent number 4. While replying the notice sent by the respondent number 4, my lord, they were silent. And even in that notice, my lord, these two specific allegations, my lord, I'm just reading it. To be very specific, the petitioner number 1, in the period 28/9/2020 to 19/1/23, had withdrawn a total amount of rupees 2,72,92,783 in an unauthorized way, which is disproportionate to her entitlement against the capital contribution she made as per the agreement dated so and so. Such withdrawal of money from the firm's bank account without informing the deponent, without any notice or consent of the deponent, violates the very essence of the agreement, my lord. Now, again, my lord, I was very specific to the allegation, my lord. Now, it is also evident from the State Bank statement of account of the firm in the period aforementioned that an amount of rupees 15 lakhs was withdrawn by one Sri Dharmeshwar Deka by check number so and so on SBI Shilpukuri branch, and another 20 lakhs, my lord, was withdrawn by one Sri Dr. Chakradhar by check number so and so. Well, these two particular transaction, my lord, I put question. Now, on what pretext or to what extent of liability that to discharge with you have issued this check, there was total silence, my lord. Even in the legal notice issued, my lord, that is there. Kindly turn, my lord, page 56. Page 58, my lord, precisely. Last paragraph. Page 58 of my affidavit, my lord. Has your lordship got? Well, there it is also evident from the statement of bank account of the firm. This is a legal notice, my lord. In the period aforementioned that an amount of rupees 15 lakhs was withdrawn by so and so by check number so and so, and an amount of 20 lakhs was withdrawn by so and so. On what that was my question, my lord, on what pretext or liability such checks were issued by the firm in favor of those two above named create serious suspicion, and the same needs to be addressed immediately, taking all the partners in confidence. As such, withdrawal of transactions until substantiated with records violates the principle of both civil and criminal. That was my lord, the recital in the notice, my lord. Now, last paragraph of this notice, my lord, see. The part of honesty of the respondent number 4, my lord, is very clear here. Since inception, my lord, dispute arose, respondent number 4 is trying to resolve this issue out of court by repeated requests they are avoiding. Even in their reply, my lord, to my allegations, they were silent. When I said that, let us sit on the table to decide this matter, because the liability towards the extent of payment of GST and all, my lord, my responsibility also goes there. So we need to settle it, but they were silent. Rather, they came up with a different suggestion that if I withdraw the the freezing of the bank account, only in that circumstances they would come up for settlement. The intention is very clear, my lord. My lord, there is one important issue, my lord. An extra one, page 55.
Page
55 of my affidavit. An extra one. Has the lordship gone?
Your affidavit pages are changed to 62 onwards, huh?
My lord, no, it's
Page, which paragraph, page 55.
the page, now this
No.
page is 55.
55.
An extra one.
Yes,
An extra one. Well, just reading it out, my lord.
yes.
This is to inform you that only for GST, my lord, I wrote a letter to the bank, one of the banks of the partnership firm, my lord. Because the notice came to me also, my lord, that we need to pay the GSTs and all. So to that extent, my lord, I wrote a letter to to this particular bank. My lord, I'm reading it. This is to inform you that only for GST and other tax payment purpose, you are requested kindly to reopen above mentioned account of our firm Pragati, and for that, hereby I have withdrawn my earlier letter. I wrote 3 letters to the 3 banks to stop the payment or to stop transactions, my lord. Now, regarding stop payment, for your kind information, the BK Tati and Associates is our tax concern. This is, well, see the part of honesty of the respondent number 4, my lord. The moment he got to know that there are statutory liabilities left to be paid, my lord, I immediately wrote a letter to the bank, one of the banks, my lord, that is Union Bank of India, my lord, Boishester branch, to defreeze the account so that the statutory liabilities could be paid. They didn't do that. They never approached the bank also, my lord. Now they have come up, my lord. Even they filed one rendition petition, civil court, my lord, for rendition of account. Now, for until and unless proof of rendition of account, if it is open, then again the amount will be siphoned off.
That's all.
My lord, but may I take your lordship to page 59. Page 59 of the last paragraph. There is one particular aspect, my lord.
Yes.
So that shows, my lord, the respondent number 4's intention. Under the efforts and circumstances, I therefore, on behalf of my client, urging both of you to convene a meeting at a place convenient to all the partners within a period of 10 days from the date of receipt of this instant notice. Produce all relevant records of transactions, both digital and cash books of accounts of the firm, with the definite objective of resolving all the dispute amicably, failing which I have the definite instruction to the normal one. Now, what they have replied to this notice, man. Page 62. Last paragraph, page 62, the lordship. Under the efforts and circumstances, your request for convening a meeting can be agreed to by my clients only if you if and when your client takes steps to defreeze the bank accounts, as aforesaid, on making the two bank accounts in the name of the firm as referred to above making operational by your client. Well, this is the condition. Now the entire status of the firm is changed now, because it is no lie, because it is dissolved. Now on the issue of dissolution of the firm, is it possible to operate again? They have come up with a request to operate the bank account, since there is one petition pending before the civil court. Certainly, even there, my lord, the next date it fixed for ADR on my request, lordship, to settle this issue, and we can certainly get away from, discharge our statutory liabilities to that extent. But can I take your lordship to section 53 of Partnership Act, my lord?
Yes.
After, this is the consequences after dissolution of a firm, my lord, partnership firm.
You have a copy of the plaint filed before the civil court?
My lord, I have. Lordship can read. 53. Section 53.
No, not this. I have a copy of the plaint act that we have. Who is the plaintiff here? You are the plaintiff.
No one.
You are the plaintiff.
Suit, my lord. Yes.
Yes.
Married lordship. Section 53 says, my lord, of this partnership act.
It's okay. Act you don't have to read. We have seen that.
My lord.
That's all.
Right, my lord. That's not. Sorry, paragraph 7 of my paragraph 7. There are 10. Just I'm
Of your
highlighting
affidavit.
one issue, my lord.
Of your affidavit.
My lord.
Yes.
Well, that with regard to the statement made turns on so reasonably basis. The deponent respectfully begs to state that finding no immediate measure, he approached the bank concerned for stopping the transactions. The bank accounts were fully operational. My lord, this is very important. The bank accounts were fully operational prior to that, and the entire accounts were managed and maintained by the petitioners. But it is indeed a question that what actually restricted the petitioners from making payment of statutory dues in due time. It is also important to articulate here that one notice to return defaulter, my lord, dated 26/1/2022 for the period 21/22 issued by GST authority was also not paid. Now the interest has come up, my lord. Now it has to be paid, even if there is a suit pending for rendition of account. So how the calculation will be done?
Obviously, you don't want me to decide the civil suit. If you want, you can just have to say yes.
Here is a case, my lord, we are ready to comply that whatever direction issued by this court, my lord. Only to avoid the future complaints, we will that.
Yes, Mr. Chaudhary, anything in reply?
Honorable friend has said many things about the, my lord, siphoning off of money. And only, my lord, would draw your lordship attention to the agreement. If your lordship kindly comes to page 28, he is, my lord, he has a share of 15% only, my lord. The other amount will be certainly huge. Page 28, your lordship will find, my lord, their capital contribution. The private respondent's contribution is only 15%, 15%. That is one. And my lord, issue with your lordship is, my lord, whether three of the partners, when, my lord, they have given a mandate to the bank that any two partners can operate, whether the bank is within its power to, my lord, to stop the transaction on the basis of a letter of one of the partners. That is the issue. The dispute between the parties, my lord.
In the current political atmosphere, we only know of a minority politician being a chief minister for quite a long time. So,
in fact, my lord, if your lordship, of course, besides the point, if your lordship, my lord, sees the percentage of votes that a party, my lord, gets, it is always the minority which is ruling the, my lord, majority.
That's true.
Always, all through, my lord. So I think, my lord, I need not give any further reply, my lord. That is the issue to be, that is false for consideration with your lordship, my lord, whether the bank would have, my lord, frozen the accounts on the basis of a letter of one of the partners who is a signatory to the mandate, which says that any two partners can operate. And any other grievance that the parties may have, my lord, that is to be decided by the civil court.
but any explanation why you have filed a writ petition? Because you approached the civil court.
My lord,
Prior to that,
we had, my lord, we went to the bank, my lord. Bank said we cannot operate this account.
It's okay, but once you appeared before the civil court,
my lord,
what is the reason to come to the writ court against the bank?
My lord, in the civil court, the dispute is between the partners. There is no dispute with the bank, my lord. That is for rendition of the account only.
No, then perhaps you giving your book section 53.
Section 53, my lord. Section 53 indicate, my lord, right to restrain from use of the firm name or from property.
Cash is also a property, bank account, balance in the bank account is also property.
True, my lord.
That is one. Second thing is that according to your own plaint, which I have only flipped, I have not read it completely, but it appears that you have given a date on which the firm is deemed to have been dissolved because of receipt of notice. You give a date also, that the notice of dissolution was received on so and so. So therefore, under the Partnership Act, the dissolution takes place from the date of receipt of notice of dissolution. Provisions I won't remember. What is the provision?
Section 44, my lord.
44.
My lord.
So it operates. So after that, naturally the transaction could not have been made, whether there is a mandate or not.
No, my lord, my submission will be, my lord. If there is one aspect, my lord, whether the firm exists or not, my lord, there are several decisions which say that even if you issue a notice, it does not get, my lord, automatically dissolved unless the court says.
No, but you take a stand in the plaint.
Yes, my lord.
Having taken a stand, then the question of whether there is a dissolution automatic or It's not a dissolution. That perhaps cannot be raised by you. You are bound by a principle of estoppel.
No, I am not raising that plea. That is the plea, my lord, that could be raised by the other side. That it doesn't get dissolved because the notice, as per the notice, it doesn't get automatically dissolved unless the my lord court says that the dissolution has taken place. And there were certain high court decisions on that. My lord, that will be a matter decided to by the my lord civil court. Now, my lord, we have approached the court because, my lord, the bank said that you cannot operate it because there is a letter from the third partner. And my lord, what happens? Assuming, my lord, the partnership is not there today, but the bank account remains. If the, my lord, partnership is not there, then the bank account becomes a joint account of 3 persons. Therefore, my lord, the plea of whether the firm exists or not, that have no bearing on the operation of the account of the 3 partners. I am not going to reply on the, my lord, the submissions made by my learned friend as to what did you do, why did you not make the payment earlier? Because, my lord, it was only his client, my lord, who was submitting the returns all through. And it came to our notice subsequently only, my lord. And that's why, my lord, we had to approach this honorable court. And the statutory liability is not fastened on us only, my lord. It is also on him. So what he is trying, my lord, he is trying to restrain us from meeting our statutory liabilities also, to which, my lord, he is also may be subject to under penalty. Criminal case may also be, my lord, instituted.
There is always a theory.
Not factually true.
My lord.
I'll sync with you. Okay, I reserve the orders. If I can upload it by evening, it is okay. Otherwise, I'll make it CAV. This plaint is collected tomorrow from the court master. Copy of plaint.
I'm grateful, my lord.
Just like the names, Mr. M.K. Chaudhary, Senior Counsel, assisted by Mr. M. Sharma, Counsel for the petitioner. Mr. K. Das, learned Counsel for respondent numbers 1, 2, and 3, and Mr. S.P. Bhattacharya, Counsel for respondent number 4. Names. Okay. If I can upload it today, then it's done. If I cannot upload for some reason, then make it. Chamber.
Now, see, there is a saying in press, if I am correct, friends, you cannot have it, you cannot have it, or you cannot take it. Either he has to take, they did not pay us the rent since 2018 till 2022. After filing this writ petition, they started paying the rent for a period of 6 months. But their plea was that, his plea was that we did not give any, or we did not carry out audit. If we have not carried out audit, how did they pay us for what is the rent for for 6 months? So therefore, their plea that we did not carry out audit for want of audit, he could not pay us rent is not correct. And there is a civil dispute. And now he has been paying what we have demanded about 60,000 per month. He has been paying us almost the same amount. So as regards to the amount also, it is not disputed. Only here and there, plus minus, that amount will come. Therefore, before this writ court, whether the civil rights, civil this thing will continue to this thing, because we have to get money from them. It comes almost about 78 to 80 lakhs from him. Therefore, at this,
this repetition will be maintainable.
My lord, in fact, it is on the face of it arbitrary. I'll just quickly point out the background, my lord. I'm not supposed to pay rent at all, my lord. It is a public-private partnership or a PPP model, as they call it, my lord. There was a space.
This is still not a issue which can be raised in the writ petitions.
My lord, I'll just, if you're, from the facts I can persuade, my lord, it is a fit case where your lordship can exercise. My lord, what had happened here was, my lord, the petitioner in the respondent number 3 they entered into an agreement. That agreement, your lordship finds at page 24.
Yes.
24, my lord. I'll just point out a few relevant clauses. Page 25, clause 3, if your lordship takes up.
No, even if it is, all the clauses are in your favor.
No, not on.
Let us assume that all the clauses are in your favor.
Alright.
Still, if it's an enforcement of agreement, it cannot be
It-
done by way of a writ petition.
It is actually not that, my lord. Here, my lord, natural justice, I'll just show, my lord. I'll just show
Those things are must have only a camouflage.
my lord,
An
what
agreement,
they've,
He has
an
not
agreement,
come
enforcement of
lengths.
agreement. Mr.
He has not
Bhagwat,
come-
please don't interrupt.
my
I'm
lord,
speaking in your favor and then you are interrupting. Then I'll adjourn the matter.
Sorry, extremely
No,
sorry.
no.
Extremely sorry, extremely sorry.
my lord,
You
I'll
see,
just.
enforcement of agreement, you see, whatever you say, let us say everything is in your favor, 100% it is in your favor. But still, it's an enforcement of agreement.
My lord, it is, what they've done is, my lord, there was an existing PPP agreement, my lord. Now, all of a sudden, my lord, there was an arrangement between us that there'll be quarterly audits and I will pay 35% of the profits generated from the business of running the resort, my lord. My lord, they did not come forward for carrying out of audit. And they had been availing the spaces in the resort. And whenever we raise bills, they say that when we do the audit, we will take our share and we'll do the necessary adjustments. Thereafter, they took a loan from me, again saying that when we finally do the audit, we'll make the necessary adjustments. Now, so therefore, for the non-audit of the accounts, my lord, it is me who was suffering. Then what they do is really surprising, my lord. They issue a notice and they say that since you have not done the audit, we are changing the entire model and we will convert it into a lease and we will induct someone else. Absolutely no opportunity was given, my lord. In fact, I'll show from that.
It's in that page 45.
Yes. Page 45, your lordship has already seen, my lord. Here, my lord,
I've only flipped, I've not seen.
my lord.
I've only flipped, I've not seen.
So during the subsistence of this agreement, my lord, agreement otherwise says that if you want to carry out a novation, it has to be done mutually. Now, unilaterally, they issue this notice and they say that we are not interested in continuing with this arrangement. We will rather convert it into a lease and will induct another lessee.
They say they will take over.
We'll take over and we'll induct a lessee. Now, as against this notice, I say that it's a bilateral contract. At least hear me out, invite me to that meeting so I can put forward my case. Despite that, my lord, they issue the cancellation notice at page 49 and they cancel the agreement unilaterally. Now, my lord, other things aside, I'm not on contractual obligations. My lord. Other things aside, my lord, even in contractual matters, since it's the state, it has to act fairly. And arbitrariness is on the face of it, my lord. How can they unilaterally revoke a concluded contract in this fashion, my lord?
Unfortunately, a prayer is only for audit.
My lord?
Unfortunately, in a writ petition, the prayer is only for audit.
No, my lord. I'm saying, my lord, audit is just a ruse to cancel the agreement, my lord.
That's okay, but what you have said this, yeah. You have issued a, you have challenging the notice of 12-1.
Yes, my lord. My lord, I'm praying for a certiorari to set aside that particular notice because that is on the face of it arbitrary. My lord. Additionally, I've said sought a mandamus directing them to depute an audit team. My lord. I might as well forego the second prayer. My lord. Insofar as the prayer for setting aside that particular notice is concerned, my lord, that remains. My lord, I can understand if there were disputed questions of fact, my lord, I should ideally approach the civil court, my lord. My lord, but going by the judgments of the Supreme Court, since it is violative of the principles of natural justice, my lord, this order in any case cannot stand, my lord. Now, insofar as who is entitled to how much, of course, that is something we can agitate it before the civil court, my lord. But so long as this order remains, my lord, they are trying to take over, my lord, on the ruse that I did not go forward for audit when the record speaks otherwise, my lord. It is I who had been insisting on audit because my payments were held up because of the non-audit. And then thereafter, they take it as a ruse to cancel the agreement and to induct a third party. In fact, my lord, there's more to it, my lord. They filed the IA for vacating the stay, my lord. After filing of the writ petition, my lord, the executive magistrate ordered that since the entire dispute is regarding calculation of the dues, let an audit be carried out. Accordingly, I supplied them with all the expenditure statements, my lord. And they did not come forward for audit despite the order of the executive engineer, which is why we made the calculation and we started making payments. Against that, they issue a letter reprimanding me that do not make any payments in our favor. And now they're complaining that I did not make the payment. That is also on record. If your lordship takes up my affidavit in opposition filed in the IA, my lord.
Yes.
Page 27, if your lordship takes up, annexure 1.
Yes.
Now, my lord, here at page 28, your lordship will find the last paragraph. Keeping in view of clause 23 and 25 of the agreement, the court asked the first party to re-examine the notice of cancellation in the board meeting and to immediately form the audit committee. The court also directs the second party to furnish all the accounts of receipts and expenditure to the first party without delay. The court directs HIDC board to immediately call a review meeting with the members and parties to discuss on the related issues and to strictly comply with the agreement and to ensure the presence of every board member. Against this, my lord, we had issued several reminders that going by this direction of the executive magistrate, please form an audit team. Those letters your lordship finds at annexure 2. And then, my lord,
Where is this letter of 4/2/2023? Where is that letter?
4/2/2020.
This order is passed in your complaint dated 4/2/2023.
Correct.
Where is that?
My lord, 4/2/2023, your lordship finds it in the writ petition at page 52. Your lordship will see, my lord.
I've seen more than what is required to be seen.
My lord, in fact, recently, my lord, the Supreme Court has again said, my lord, that bar is not absolute. My lord, if on the, I can show from the materials on record, my lord. Paragraph 19 onwards. 20 or 99. 21, your lordship. If I may read, my lord.
Just now. Will this apply on the facts and circumstances of the case?
Well,
There is
the
a case
broad,
where you have entered into a agreement which is a lease agreement.
no, my lord, it's not a lease.
PPP, but actually you are taking it on lease.
No,
A
my
part of that, yes.
It's a partnership agreement. My lord, if your lordship sees the contract itself, Page 24 of the writ petition. my lord.
Because it says that that the
My lord, in fact, both of them are required to make capital investments. There's a profit sharing ratio stipulated, my lord.
you see this agreement at the what do you call introduction, Sri Ashok Gupta so and so. Hereinafter referred to as the second party tenant.
My lord, true, my lord, but to gather the true purport, my lord, will see the agreement in
Yes.
toto. My lord, first, the first clause, my lord.
Yes.
My lord, first the recital B, if your lordship takes up. The parties hereto of the second party showed interest for participating in the public-private partnership PPP model with the first party to start business of hotel and resort while letter number so and so. Whereas the board of HSIDC in its 163rd adjourned board meeting held on so and so has approved the proposal of participation in PPP model for opening a hotel and resort at so and so complex and thereby authorizing the managing director to sign and execute the agreement. Some of the clauses.
Mr. Dekha,
My lord.
you see, I'm on a different page when I'm reading this. You come to this paragraph, paragraph 20 of the agreement. That in case of default in making payment of monthly or quarterly ratio for consecutive 3 months, the owner shall have a right to proceed for eviction of a tenant from the suit premises.
I get that, my lord. Even in the description is shown as a tenant, my lord. But
No,
if
not
your
that.
lordship.
Not that, but you see the process of, it's basically agreement where determination is also envisaged.
True, my lord.
So those agreements were not there when when you are citing this gas authority, because you see here what is, it's a case of supply of gas.
Correct.
And when it's a supply of gas and the non-payment would be a circumstances which is covered by Sale of Goods Act, where an unpaid seller has a lien over the supply and therefore it can stop.
Yes, my lord.
Provisions I won't remember. I've forgotten the provisions. But this is not a case of supply of goods. Therefore, the ratio of the decision of the Supreme Court in this matters would not govern circumstances where an eviction of a tenant for non-payment of dues is alleged. So therefore, civil code is the only remedy.
My lord, why I placed reliance on that just to gather the broader principle, my lord, to decide this particular issue, whether the cancellation was arbitrary and violative of principles
Here,
of
we come to para 24 of this order, which you are citing. That is the reason why the court examined this.
Yes, my lord. There is an alternative remedy, my lord. There's no dispute regarding that, my lord. But would that by itself curtail the remedy under 226 is the question, perhaps, my lord.
No, it's a question of it's a language of Supreme Court. It says when a writ petition is when a civil dispute is couched, it says in a matter of criminal jurisdiction. When it says that a civil dispute is couched in a complaint which gives rise to a criminal, which I forgot the language. Where it's a criminal element is brought in. Then the court will look into it and it will shaft the grain and the shaft will be separated. So that is the language in one of the decisions.
What I'm on is, my lord, to decide on the validity of the cancellation order, my lord.
It can't be a writ court which will decide the effectiveness of an agreement, saying that whether this is a case where the petitioner has gone excess of its jurisdiction to slap you with your notice of eviction.
My lord, if it's on the face of it arbitrary and violative of natural justice.
Every eviction of a tenant by a landlord is arbitrary.
My lord,
Non-payment of rent. If one goes to court, he will say, the tenant will come and say arbitrary. Anything
no, but
happens. Bank wants to recall the loan. It says that it is arbitrary. They could have extended time for recalling by 10 days.
True, my lord, but if your lordship sees 25, clause 25.
Yes.
Clause 25, my lord, any amendment pertaining to terms and conditions, etc., may be done on mutual understanding to run the business, etc. Now, if your lordship turns to page 49 again, my lord, what are they trying to do, my lord?
Paragraph 15 they have invoked of this agreement.
My lord,
I can't help it. It's a civil dispute.
my
I
lord,
can't
15,
entertain this.
going by 15 also, my lord.
Now you tell us, you think yourself to be the court. And now you say when these disputes are there, how will you decide it? Just formulate me an order where you can say that this is something which will invoke Article 226.
My lord, I'll say the action of terminating the contract or introducing amendments unilaterally, being on the face of it, dehours the clauses of the agreement and on the face of it arbitrary.
Why we have Urban Area Rent Control Act where your rent is 1,000 rupees.
My lord.
The landlord comes and says, now 3 years have gone by, prices have increased. So give me 1,100 rupees. So you go to civil court for determination. Why it can't be decided that it is so arbitrary, 100 rupees enhancement of rent is so arbitrary that it affects Article 21, right to livelihood.
No, my lord,
Right,
there again, the statute itself provides for a determination of fair rent. Now,
Therefore, here also, when it's essentially the language of it is tenant. Now you are asking the court to read it otherwise.
my lord, if your lordship,
Therefore, it would mean that you are also asking the court to have a novation of contract.
no, I would not insist on that. If your lordship sees clause 3:12,
3, yes. Business of the hotel will run a PPP mode, 65-35 ratio.
4 again, shall hold 35% ratio, while the second party shall hold 65% ratio. And thereafter, the second party shall have a right of management and administration of the business project, subject to consultation with the first party wherever necessary. Clause 12 again, my lord. The first party will invest 25% of capital investment with the second party against new building constructions, if any, whenever necessary and subject to availability of fund of the Revival Corporation. 17 again, my lord. Second party will maintain all accounts and relating to receipt and expenditure of the business transparently. The first party shall have the right to audit accounts quarterly by the audit committee of both first party and second parties comprising of 3 members. So there is no consideration of rent or any license fee, my lord. It is all dependent upon the profits that are generated from the business. Now that naturally requires an audit, my lord. Now, despite these clear clauses where they have defined a clear profit ratio, my lord, where there are stipulations regarding capital investments, my lord, can I by any stretch of imagination be held to be a lessee or a tenant, my lord, or a licensee for that matter?
We don't know, it's an agreement between the parties. You have both chosen your partner.
My lord, and now, my lord, I'm not urging the court to interpret this contract. My lord, goes by the contract and the notice at page 45. My lord, for a moment, if I may just read that notice, my lord. With the subject cited above, I am to inform you that the management of the Revival Corporation is going to place before the next board meeting to review the following clauses of the agreement dated 1st December 2017 to follow the agreement model so-and-so unit Borough Haflong on monthly fixed rent system. So this is the amendment. It is only by this amendment they want to transform it into a lease, my lord. Now, clause 1, the PPP agreement may be renewed for duration and terms and conditions as may be mutually agreed upon between the owner and second party. The word renew shall be replaced by fixed for 10 years. There will be no renewal system in the terms and condition. It will be open bid after expiry of 10 years. The words mutually agreed upon does not arise any longer. Now, clause 3 and 4 again is important. the business of the hotel will run on PPP model with 65-35 ratio. The word 65-35 ratio of profit will be replaced by the word monthly fixed rent as the board deems fit and proper. So it is by this particular notice that they want to now transform it into a lease. Now, can that be done given that it's an instrumentality of state, my lord? It has to act fairly. In any case, any contracting party cannot resort to novation unilaterally, my lord. And here we are dealing with the state, and the state, during the subsistence of the agreement, attempts to sort of change the entire scheme of things and to sort of convert a PPP model arrangement to a agreement. And I'm not even given a chance to my lord, appear, because on the following annexure at page 47, your lordship will find, after this notice was sent to me, my lord, I responded by this letter dated 2/11/22. I write, my lord, with reference to the subject cited above, I request you to kindly involve the second party, Ashok Gupta of so-and-so, in the 171 board meeting, as I am your highest sharing shareholder partner that has invested more than 1.5 crores in renovation, extension of the building, electrification, land scrapping, gardening, painting, etc. in our agreement dated so-and-so between so-and-so, working under the banner of Kanch Hotel and Resort to discuss the points raised in your letter for smooth functioning of our agreement dated so-and-so. Now, despite this letter seeking an audience, my lord, that was also not granted to me. My lord, does it not violate natural justice, my lord, considering they are an instrumentality of the state, my lord? My lord, other things aside, whether contractually, what are my rights and obligations, besides those facts, my lord, even if we go by this letter, I'm at least entitled to an audience, my lord. I have been investing. Now, next letter is at page 48, my lord. They do not involve me in that entire discussion and they cancel my agreement. So on this ground alone, my lord, in my respectful understanding, we can invoke the jurisdiction.
Where is this impugned letter?
Page 48, my lord. So my request goes unheard, my lord, and then they issue a notice with reference to a subject cited above. I am to forward here with the notice as well as the decision of the 171st board meeting of the corporation for cancellation of the agreement dated 1/12/2017 between HISI DC and Shri Ashok Kumar Gupta so-and-so on the matter of Kanch Hotel and Resort Dijali, a joint venture unit of Assam so-and-so. So for a moment, my lord, if we forget the other contractual rights that are bestowed upon me by that agreement, my lord, this notice by itself would show that I was denied even a right of hearing, my lord. Which is why the executive magistrate also subsequently, my lord, said that this decision needs to be reviewed. And in the meantime, you can exchange your accounts and expenditure statement.
What is the power and authority of district commissioner to pass such orders?
My lord, that it falls under the Hills Area Department, my lord. And so therefore we deemed it fit to approach the deputy commissioner, my lord. And the deputy commissioner later on forwarded the
Very near to this deputy commissioner's office is the civil court.
my lord. My lord, we were running from pillar to post, so therefore we send that representation, and the DC was gracious enough to forward it to the executive magistrate, my lord.
Yes, anything in reply?
Chief, it is agreement was made in the year 2017, effective from 2018 till 2023, till the notice was issued to him. He kept quiet. He did not pay anything. All right, there should have been a letter that he is not in a position to pay. Now, only when filing this case, in petition, he started paying for 6 months. At that time, there was no statement. At that time, there was no audit reports. Statement should come from the persons who is occupying the business, who is doing the business.
You're not the rate petitioner, you are merely to reply. You are not the rate petitioner.
No,
Whether he paid or not is not your grievance.
he has, no, he have, that is why he has not paid, that is why.
That's okay. He has not paid,
Therefore,
that's a fact. But you did not agitate your right.
No,
For non-payment of
we
rent.
actually, I'll tell you, Lordship, that corporation has been running pillar to post for a long time. It was defunct since 1992, because I have been a standing counsel for the organization since 2005. It was not able to run, not able to pay the salaries to the employees for a long time. After all,
That is their mismanagement.
no, Lordship, at that time, it was run by
That is
civil
their
service,
mismanagement.
civil service officers.
That is their mismanagement.
Yes, it was exactly. I must say that it was a mismanagement, and this all happened because of all these things. They thought that they will get some money out of this unit also. But my submission at this stage, that they have not come with a clean hands. They have not paid us any. They did not pay us rupee as record under as a tenant. So therefore, when a tenant is not paying us, he is a defaulter. He is supposed to go, and all those things, whether he is not a tenant or he's a tenant, all those things will come with evidence. Therefore, it should go to the place before if he is agreed, he should go before this civil authority, civil court, not here, not in the writ court. And all those documents, clause by clause, will be examined. It needs evidence.
Okay.
My lord, will permit me to just, since he's ventured into that question, my lord, just for a moment, if your lordship takes up an extra 7 onwards.
Page, give me the
Page
number.
34. Now here, of course, there's a typographical error. There was a request to go through it says assignment, it should be assessment of last 2 years. Now, my lord, the following page at page 35. I'll show, my lord, why this audit was actually not carried out. Now, page 38, my lord. I am running the resort, my lord. Their officers also use that resort for fooding and lodging purposes. Now, my lord, page 35, my lord. My 23 numbers of bills are pending. So they adopt a resolution, my lord. Down below, after the bill and date particulars of the bills, your lordship will find rupees so and so duly checked and may be approved and released or adjusted against 35% profit ratio as per our sale procedure agreement receivable as the corporation presently passing through financial crisis due to non-receipt of government funds. So when I raise bills, they say that we will do it when we do the audit. Today, we don't have money. Now, page 37, if your lordship sees. This is dated 2/7/22. Please find enclosed with this letter bills of accommodation and fooding bills related to your verbal telephonic order, and also enclosed document of persons who stayed for your needful action and order, and request you to kindly depute audit person for assessment of profit of resort from date of opening. I make that request. Since you are holding up my bills, saying that we'll pay you after the audit, please depute an audit person. Now, my lord, then there are again pending bills which are innate. And if your lordship may skip over to page 40 again. Receive rupees 5 lakhs only from so-and-so Ashok Gupta by check number so-and-so as temporary loan for the purpose of purchasing packing materials. And the same will be returned repaid with marginal interest, if any, to him within August 2019. So they are in debt, my lord. And then page 41, my lord. Again, I write to them. At the same time, please find and enclose the later bills amounting to rupees so-and-so for payment. At the same time, I request you to kindly issue order relating to stay in resort, as your act is asking, accountant is asking under whose instruction room is allotted while verifying bills. So, my lord, they issue verbal orders and then they refuse payment. Then I write, lastly, I request you to kindly depute your person for financial audit of the resort from 18 June till date, and also issue money receipt of 2 lakhs and rupees 1 lakh respectively, which was transferred to your account. So I have been extending them financial assistance, my lord. They are deferring payment on the ground that they'll do it when the audit is finally done. I send request after request that please clear my bills, please issue clear orders for lodging and fooding, and also depute audit personnel. Now, page 42, my lord, their response, if your lordship sees. 42, this is a letter dated 31/10/22. With the subject above, I'm directed to inform you to kindly provide monthly receipt expenditure statement, including receivables and payables from your end from the month of February 2018 till date to ascertain in the profit and loss account of so and so on the basis of 65:35 ratio as per clause 4, 16 and 17, etc. of the agreement. On the other hand, we do not have the manpower of accounts personnel to audit the same in your office. So after I send repeated requests to deputed audit personnel, my lord, they ask me for statements and they say we do not have sufficient manpower to carry out an audit in your office. Now, my lord, page 43 again, if your lordship sees, my lord, it is apparent that I was cooperating. It is they who were sort of avoiding an audit, because they know once they do the audit, they'll have to account for all those food and lodging bills that have piled up over the years. Then again at page 43, my lord.
Mr. Bhagwati, you tell us what is your relationship with the petitioner? Do you accept him as a tenant or you accept
Yes.
him as a PPP partner?
He's a defaulter tenant.
He's a defaulter tenant.
And even public policy says
No,
that
I don't know. You take a decision. I am asking you a question. You have to take. You have to take a call. You accept him as what?
I accept him as a tenant who is staying in our
Well,
resort.
if that is the answer, then the reparation has to be allowed. because of the fact that you cannot evict a tenant without due process of law.
Due process, in that case, we issued notice. Clause is there,
That is
3
not
months,
due process.
or even. No,
How
my
will you
submission,
take over? How do you propose to take over?
my submission before this honorable court is that by clause so and so that 3 months notice. If he evicts it, if he goes away, all right. If he doesn't go away, I have to go to civil court.
So therefore, writ petition has to be allowed.
My submission before this court,
Writ
only thing
petition has
stay
to be
order should
allowed.
be, stay order should be kindly vacated. We will go to civil because we have to get money from him, huge amount of money.
It's okay, but you can't do it. I'm taking tactics.
We are not doing arm twisting tactics. Only thing, stay order may kindly be vacated because
No,
of
we're disposing of the writ petition itself. We are not keeping it pending.
only thing it is a civil matter. Civil court has to look into it. Needs evidence whether he is supposed to give us money or say we are supposed to give him money. But he is a defaulter without paying rent since 2018 till 2000 September
That's okay.
2022.
You enforce your agreement in the manner prescribed. Third. Mr. B.D. Dekal in counsel for the petitioner, as well as for the Hill Area Development, Ms. Barwa, you'll be appearing. Ms. S. Barwa, government advocate appearing for respondent number 1 and 2. And Mr. B.K. Bhagwati, learned counsel for respondent number 3. In this writ petition filed under Article 226 of the Constitution of India, the petitioner projects that they have entered, that he has entered into a public-private partnership agreement with Assam Hills Small Industries Development Corporation Limited, within bracket respondent number 3, by which the petitioner was permitted to start the business of hotel and resort. Most of the said agreement was for an initial period of 10 years, commencing from 1/6/2017 to 30/12/2027. The sharing of profit and loss was agreed in the ratio of 35:65. No, sorry, it's 65 is to 35. 65 is to 35 between the respondent number 3 and the petitioner. Full stop. The next paragraph, the petitioner projects that from time to time, he has extended service of providing food and lodging to the guests of the respondent number 3, and also requested the respondent number 3 to make an audit of the business from 1/6/2017 onwards on several occasions, but audit was not conducted by the respondent number 3, who was bound by the agreement to do it. Full stop. However, the respondent number 3 by a letter dated 31/10/2022 addressed to the petitioner sought for unilateral review of the agreement and proposed to alter several to alter clauses, clause numbers 1, 3, 4, 5, 6, 12, 15, and 16. Sorry, no, more than that. 16, 17, 20, and 25 of the said agreement dated 1/12/2017. First of the learned counsel for the petitioner submits that the amounts to novation of a contract. Which is sought to be done without involving the petitioner in the negotiation. Full stop. This was followed by issuance of a notice dated 12/1/2023 by the managing director of the respondent number 3, by which notice dated 12/1/2023 for cancellation of the agreement and for eviction of the petitioner was provided, and the respondent number 3 also threatened to take over the premises on the expiry of the time provided in the said notice. Accordingly, this writ petition has been filed under Article 220. Sorry, accordingly, this writ petition has been filed with a prayer for setting aside the notice dated 12/1/2023 and for a direction to the respondent number 3 to carry out audit in terms of clause 17 of the agreement dated 1/12/2017. Next. The respondent number 3 has contested this writ petition by filing sorry, occurring an affidavit in opposition. Also, similarly, the District Commissioner Diffu, within bracket respondent number 2, through his subdivisional officer within bracket Sadar, has also filed an affidavit in opposition. Next. from the next, the learned counsel for the respondent number 3 has submitted that a huge dues receivable by the petitioner has accumulated and according to their calculation from 1/1/18 to 13/9/2023, we have to receive a dues of rupees 55, 47, 600. Which is on account of rent and or 35% share of Kanchki NCH Hotel and Resort as per agreement dated 1/12/2017. And accordingly, it is projected that the respondent number 3 board, the board of respondent number 3 had decided to fix a minimum rent of rupees 60,000 per month with increase of 10% after every 3 years. By board resolution dated 16/12/2022. Next, referring to the statements made in interlocutory application, the IAC 2386 of 2023, filed by the respondent number 3, what is projected that the agreement between the parties contained clause 15, which gives right to the respondent number 3 to cancel the agreement and to take over if not found, if the performance of the petitioner is not satisfactory. Is also projected that the eviction of the petitioner. No, it's vacating of the premises by the petitioner is in the interest of revival of the corporation as it is suffering huge losses and is unable to pay rent. Sorry, the pay is salary and salary of the staff and officers. And in this regard, it is also projected that during the currency of the agreement, the respondent number 3 corporation had to take loan of rupees 7 lakh from the petitioner, which is subjected to return or adjustment. And it is also projected that the respondent number 3 corporation has already written a letter to the District Commissioner Kalbi Anglong, Dikru, requesting eviction of the petitioner from the property of the said business. Next paragraph. On the documents annexed to the writ petition, Where is that order of the deputy commissioner?
But that is in my affidavit in the IAM. Page 25. Page 27 of my affidavit.
27 is the complaint. Oh, order. Oh,
Order.
sorry, first line is complaint, so I was reading it wrongly. Interpretation of documents annexed to the. The writ petition as well as affidavit in opposition filed by the petitioner in IS Civil 2386 of 2023 that on receipt of a complaint, letter dated 4/2/2023, comma, an executive magistrate at Diffu Caribbean Anglong has passed an order dated 2/3/2023 issuing direction to the respondent number 3 board to call a review meeting with the members and parties to discuss the related issues and to strictly comply with the agreement and to ensure the presence of every board member. Stop. The next. Although this said order is not under challenge, but from the contents of the said order, it is not discernible under which provision of law which provision of law is invoked by the learned executive magistrate Diffu to pass such an order. Therefore, appropriately, the comment is made as to the legality of the said order. Or enforceability of the said order. Next point. Essentially, the dispute between the parties arise out of the agreement of MOU dated 1/12/2017, which envisages participation of the petitioner and the respondent number 3 in a public-private partnership or private-public partnership, public-private partnership model for opening and running of hotel and resort. The said agreement is for a period of 10 years. Stop. On a query of the court, the learned counsel for the respondent number 3 has submitted that as a lot of rent has become due, the petitioner is required to be treated as a defaulter tenant. Stop. Be that as it may. Insofar as the respondent number 3 is concerned, their grievances regarding non-payment of the 65% dues arising out of profit and loss. If any. Notwithstanding that, clause 15 of the said agreement envisages that the respondent number 3 reserves the right to cancel the said agreement, including takeover, if not found satisfactory with 3 months notice from either side. Nonetheless, the power to take over has to be read to be permitted, to be done as permitted in accordance with law. As the tone and tenor of the impure notice dated 12/1/2023. You give the number also, page 49, numbers mentioned. Students, the petitioner of taking over of the Kanch Hotel and Resort by giving a notice to vacate within 45 days. Comma. The takeover can only be in accordance with law. In a manner prescribed and in no other manner. Next paragraph. Under such circumstances, comma, when a notice of cancellation of the agreement and taking over of the premises already issued on 12/1/2023, comma, it would not be open to the writ court to set aside this said notice as the respondent number 3 is exercising its right as envisaged in law. The only anxiety that the petitioner can lawfully have is to have protection till they are evicted in due process of law. Therefore, comma, insofar as the notice dated 1/12/2000, so 12/1/2023 is concerned, no case is made out by the petitioner for passing of the said notice. However, comma, at the same time, comma, the although there is no prayer in the writ petition for any protection to the petitioner, no, but as the notice envisages taking over the premises on expiry of 45 days, comma, the manner of taking over having not been prescribed in the agreement nor spelt out in the notice dated 12/1/2023. Now the court is inclined to provide that the eviction of the petitioner can only be in accordance with law and in no other way. Yes. Accordingly, in view of the discussions above, this requisition stands partly allowed to the extent as indicated above. The interim order passed on
22 to
22
to 23.
to 2023. Stands modified by providing that the eviction of the petitioner should be in accordance with the Puspa. In view of the order passed, this will be high. In view of the order passed today in the WPC 90 of 2023, this interrogatory application stands closed.
The amended clauses by that notice, Manoj. The notice envisaged termination.
They are only giving a notice. You take your stand in the civil court. Just be a question. It's clarified that if the petitioner is also aggrieved by any of the contents of the said notice, they are also free to approach the civil court in accordance with.
Right.
Time being item 37.
Just a moment, this. No, I find Mr. Pathak here. That election matter. Right. Just a moment, I'll put one matter, I'll take it up. No, I'll take up one matter and let's take up this election matter. Item 37. Yes. Please wait for some time. Both sides are there, or you are also there? Oh, okay. Then okay. Yes.
My lord, here in this case, my lord, the petitioner got a land, part of the land from the father by way of gift.
No, we posed a query. Ms. Begum was here, we asked her, we gave a query. You see, we assume that you and Mr. Mahmood are two brothers. Correct. There is a land in which you have 50% share. Once you file a suit for 50% of that share.
I have not filed.
No, whoever files, I'm giving you an example. My example may be inappropriate, but or horrible, but still bear with it. Now you file a suit for this 50% right over that land.
No, he has filed suit for cancellation of gift deed.
But he's asking for 1/4 share.
1/4 share.
So that's why you see, I'm telling you, my examples may be horrible, but you bear with it for a moment. 50% of the land you are praying for in a suit for a right title in interest.
No.
Can you file a consolidation proceeding in the GMC saying that there will be a consolidation of the two properties and then one permission can be granted?
Here in this case, it is not the case. Here is the case only splitting up of holdings. Splitting up of holdings means suppose there are two floors, then also it can be split. Suppose I am holding a portion of the land. Even if tenant is also holding, then also he is entitled for holding for assessment of tax with respect to that portion only, not other portion. And here in this case, my lord, suppose his suit is decreed that the gift deed which was executed in my favor that cancel, then also I have a right over this suit land. Then also I have a right.
How?
Because I am co-owner, father died. During lifetime of the father, portion of that is my portion has been gifted to me only by way of gift deed. And remaining portion are in possession by the other brothers. That means he is in possession. So even if his suit is allowed, suppose today his suit is allowed, then also I am entitled for share over this land. So I am not on all these things because initially they have filed a suit for cancellation of gift deed. That suit injunction
has been paid for. Injunction was not granted. And this honorable court also in civil division petition make it clear that I may construct the house subject to my own risk and cost. Then I applied for
This suit is, what is the number of the suit?
39 of 2013.
Which page is it? Annexure 8?
38.
8, annexure 8?
38.
38.
And this order, my lord, was passed by the executive officer. And this order ought to have been passed by the board. It is under section 83. Board has the power.
You see, is the executive officer alone who is constitutes the board now?
No. Board is
Who is the board then?
Silchar Municipal Board.
Who is the board?
Chairman and it's all.
Chairman is not there. If there is a chairman, there can't be an executive officer.
That is the question. Chairman was there. Not only chairman was there, but even now also the chairman is there. And I have filed application for splitting up of holding because one holding is in.
It just shows on 4.3, the chairman was there. It shows that because technically an executive officer he is not there under the, you just see this.
But at the relevant point of time, chairman was there or that is the question. At
He
the
was there.
relevant point
He
of
was
time.
there on 4/3
Then if he's there, he can't pass
2023.
an order. Because this is an order to be passed by the board.
Definitely, my lord.
Then
But-
the executive officer is not a board.
Not a board, but
Other, he is to be empowered. Otherwise, the board says that
Yes,
by so and so we empower you to pass an order. Then it's separate. If it does not have that authority,
yes.
which is that provision, board.
And notice was.
No, where is the power of this board
Yes.
section?
Page from 76, section 76.
Section 76.
Lordship got it.
No, not
Board
76.
to determine the valuation of holding.
No, splitting up is not by that. Splitting up of the board is.
Determination of rate of tax on holding. It is 80. This is the tax upon annual value of holding on holding.
80.
From this 76 to 80, then 83. Under 83, notice has been given.
This is to be done by the board. But then is this notice of page 38?
Yes.
It says that the board took a decision, paragraph 2 of that letter. The Silchar Municipal Board by order dated has kept the mutation pending. So it's a decision of the board.
No, no decision was taken. That is why I have come.
But you see, this notice mentions. 24.
Mentions. Notice mentions.
Ah.
But when order was passed, there was no mention. Apart from that, when the notice was also issued, that was also not reflected in the board's meeting.
No, we can't accept that. Have you, how do you say that this, no order was, no board meeting was,
That is why I have made Silchar Municipal Board as a party in this case.
who's appearing for Silchar Municipal Board?
Mr. S.
He's not come. Mr. S is the senior counsel.
Yes.
Then let's try to see Mr. S Datta, senior counsel. Let's wait for some time then.
Or it may be any other day. I mean.
No, you see, every time we can't, every time the file goes home. We can't spend that amount of time. Just wait for some time. If it's not there, we can't wait.
Item 47 for hearing.
Wait, please, Lordship. Lordship, I have filed an IM, Lordship, 1168 of 2024.
Mr. Pathak,
I think it's a
can
corrected.
can I ask you what has happened to this Supreme Court?
The SLP has been allowed.
Allowed.
And that election petition has been dismissed. That other election petition has been dismissed. Election petition number 1, we filed an order 7. So as against that order 7's order of this High Court, we went in SLP.
So that was allowed and the
That is
election
allowed
petition
and the
dismissed.
election petition has been
Okay.
dismissed.
So now at least.
Now everything will say.
Have a way.
I have a copy of the order also.
It's okay. We'll
But-
see. The other matters are being held up.
Yes. Because now,
Because
may I take a look?
every time. I
Peculiar
take up an-
dimension has been given by the Apex Code. Previously, our understanding, because that was the law, that moment immovable property or movable property is not disclosed, that per se becomes a corrupt practice. Now, slightly in Arunachal matter also I lost. Now that law has been modified to an extent that movable property, the connotation is much bigger. So therefore, number one, what was the value of that movable property? What is the worth of that movable property to influence the voter so as to attract 123 of corrupt practice? And
UCL has expanded.
That has been either diluted or expanded. And another aspect, which I unsuccessfully argued before Arunachal bench in another case, but now the law has been laid down. That Apex Code in earlier decisions said it's a corrupt practice. That means a legal fiction was created within the definition of 123, that suppression of these things comes within 123. It's a legal fiction. Then my argument, unsuccessful argument was, but Supreme Court has never said that you are absolved from the liability of how, where, and how, when the voters got influenced by that kind of non-disclosure. So that now has been said that yes, merely saying that this is not disclosed, that may come within the legal fiction of corrupt practice, but that doesn't absolve an election petitioner to say specifically in the pleadings how, when, and where. These are the material facts as per Azahar. So these have to be pleaded. Slightly now, it has changed.
So it's now become difficult for an election petitioner.
Very difficult. And after this new judgment, because at the bar we argue every kind of things, but I was not hopeful that Because that law was that moment you have not disclosed, that per se becomes a corruptor. But in this case, there is like, my colleague will make a submission, then after I have a submission.
IA number?
My IA number 1168. Supplementary list writing. No, supplementary list writing number last.
1168.
It is listed in the supplementary list. Along with item 47. This is an application under Order 3 Rule 4, Lordship, for striking out our name as Lordship.
You can allow it.
I have one submission. Now a motion has been submitted before your lordship for withdrawal of representation. And in section 107 was deleted in 1966. Then a new detailed procedure was brought in for withdrawal of not suit, withdrawal of election petition. In the present case, it is a withdrawal of representation. So may I have the indulgence of your lordship to submit that let the notice of this go to the election petitioner, because it's a corrupt practice challenge, directing him to appear either personally or through legal representative on a.
That would not be required under Order 3, under Order 3. I'll tell you
But-
why. Because he is annexed to this, a notice of withdrawal,
Withdrawal of his representation.
his representation.
But whether it will, I don't think in my humble order, section 108 will apply in this case,
No,
RPM.
I'll tell you.
So therefore, might be order 7, rule 12, I'm sorry, order 17, rule 2, read with order 9, with by virtue of section 87 will come in.
Go strong.
I may be in the, what was it, 107, 108 was delayed, it is 109. These provisions relates to withdrawal of suit, election petition.
Just now, I'll tell you.
Order 17, rule 2. No, it is withdrawal of election petition.
You see this? I put up two pink flags.
My
This is only to show the chapter.
chapter 5.
Yes. And then next flag. Representation of People's Act. 68, 7 and 68.
No, here minus 68 relates to a party desiring to cancel ukalatnama
And then next.
filed
Advocate-
by him in any appeal or other proceeding in this court must file a duly stamped and verified application for the orders of the court unless the advocate who accepted the ukalatnama signifies his
Then next.
willingness to retire from the case, in which case the application need not be filed.
Next, then.
The deputy registrar shall endorse the
that before
date
that.
of
The
reception
advocate
of
for any other reason. Starts at 67 then. Advocate for.
an
any reason.
advocate may also, for any other sufficient cause, or after such notice to his client as may enable him to appoint another advocate by leave of the court, but not otherwise, and on such term as the court may order as to refunding any fees he may have received, withdraw from the further conduct of the case. This is an application he has filed now.
So therefore, we can permit that.
We can permit, but what my submission one step ahead was that election petition trial has to go on day-to-day basis. So what I submitted was that a later notice be issued by the registry directing the election petitioner to come personally or through his authorized representative. Because on the date fixed by your lordship, if he does not come or does not appoint a new advocate, order 17 rule 2 will apply, I think, because order
But
17
even
rule 2
without
CPC
that, even without that, if the lawyer is withdrawn, technically he is given a notice that he will not be appearing.
not being appeared.
So therefore, the question of the court to give a notice is not at all envisaged. So then what happens is that we have found in many cases where because of our burden, taking up of the burden of issuing a notice, then endlessly we have to issue notices because AD card do not come up, it is not served, it is returned back, he is out of station.
If your lordship permits, may I know one thing? I mean, letter from লিখি দিছে না আজি ডেট to fix আছে বুলি
Issue earlier date, I'll give you.
আজি যে ডেট ফিক্স আছিল এইটো কথা তুমি পিটিশনলৈ জনাইছা নে?
No, it was before, on the earlier date.
Because this was never fixed otherwise.
But now
What I can do, lordship, is that I may give one last notice to him that there is, or it's been done and that he
no, you
may.
should intimate the date fix. Either then on the date fix, if he does not come, then order 17 rule 2 will come, then order 9 will come in automatically. Then your lordship can take care of what exactly is.
I can intimate this order to him, what of last time, lordship.
আর নহলে
Fair.
I have no issue. I can do it, lordship.
because RPAC as such does not envisage this situation. So we have to take help of section 87 of RPAC to come through the window of CPC, I think. That is exactly what I wanted to submit. Because we are in the midst of an order 14 preliminary issue hearing.
Yes. But Mr. DJ Kapil, learned. But Mr. DJ Kapil, learned counsel for the applicant. As well as Mr. KP Pathak, learned senior counsel, assisted by Mr. I Kalita, counsel for the opposite party number 1. And for
Party number 2, lordship.
What's the number?
Opposite party number 2.
you'll be then
Opposite
Karimuddin Barmiya, you will be 2,
Yes.
opposite party number 2.
Return can.
Next paragraph. The learned counsel for the. No, you just say. counsel for the, not counsel. Mr. DJ Kapil, learned counsel. And Mr. K. V. Pathak, senior counsel, assistant director counsel for the opposite part number 2. Next, the applicant is a counsel of the opposite party number 1 in the proceedings of election petition 5 of 2021. Where the opposite party number 1 is the election petitioner. On the ground that relevant instructions have not been received, the applicant has served notice dated 13/2/2024, which was sent by registered post with AD, and the postal track report is also annexed to this application. Next paragraph. The opposite party number 1 may not have the notice of the fixing of the date today. The court is inclined to direct the learned applicant to issue a fresh notice to the opposite party number 1, indicating that the matter is next fixed on.
So it takes 2 weeks to reach via registered post.
Yes. No, because if I'm sending by registered post 4 weeks, it has to be adjourned. Otherwise, General Process Act, we can't take recourse to. Days 29, 22. This one 24/5/2024. Fixing date of sense of as the next date of the connected IA civil.
Huh?
3102 of 2021. 3102 of 2021. 3102 of 2021. Fixing the date of the IA. 3102 of 2021 or 22. 22 or 21.
আমার টু হেৰি আছিল 3102 মাইলো order 7.
What should be 22? I think yes, 21. 22. In the connected election petition 5 of 2021.
Madam, I'll submit the notice, copy of the notice to the registry. We will place it on the record. Because
okay, the
postal
the copy of the notice, postal track report, sorry, postal receipt and the postal track report may be furnished by the applicant to the registry.
If the next
tag
date,
with the record.
if the next date can be on 22nd or 28th, anything's up convenient to it. Either 28th or 22nd of May.
No, 4 weeks time we have to give.
4 weeks.
We're doing date tomorrow, so 28th.
28.
Okay, 28. 5/2020.
May I also have a further indulgence? Let the election petitioner be also directed. The next date is fixed for orders, already part-heard hearing, order 7 application, as well as the preliminary issue, because otherwise next date he will say, I do not know.
Yeah, you're right. No, that is where 3102 we have stated. for hearing on 3102.
My lord, that also can be done, and or else it can be reflected in the order that
3102 being an application under order 7 rule 11,
along with a preliminary objection.
as well as preliminary objection raised as to maintainability of the election petition.
My lord. Preliminary objection for the election petition.
Maintainability of the election
Election.
petition. Okay.
My lord, I'm opposed.
Just one more, 3102, you're right. In view of order passed today in IA so and so, the hearing on this application stands deferred.
Right.
List on the same date.
Obliged.
I do. Yes.
37.
Mr. Datta.
My lord, I'm sorry, when the matter
okay.
was called up, I was not there.
Mr. Datta, now Mr. Ghosh is stating that on this date, 21/9/2021, this you will find at page 38. This is lending your petition,
Page, my lord?
page 38.
Yes.
In the second paragraph, last two lines you'll find the Silchar Municipal Board by order dated 21/9/2021 kept the said mutation process pending.
Yes.
Now, Mr. Ghosh is saying that on 21/9, the board never took a decision. He says
Decision
that
was
it's,
taken.
the date given here is fabricated. It's not even existed.
My lord, in fact, so far, Silchar Municipal Board is concerned. Now, board is not there. It's run by executive officer. Because
No.
election was not held.
No, but now it's okay. But Mr. Mahmood and Mr. Ghosh are saying that at that time, the board existed. This date is this is the 21/9/2021.
I said that perhaps at that time board was not in existence.
No, you
The
said
time
it
of
was in
passing the
existence.
board order.
And for a long time, my lord, board is not there because, my lord, municipal board is going to be, my lord, upgraded as corporation.
Correct. So then also this notice, it says the board took a decision. Then it is not the board, it is an executive officer who took a decision.
Obviously, my lord, because in absence of board, my lord, obviously the executive officer can take any action. Because board is not there at all.
Okay. Can you find out, because this is,
My lord, your lordship can fix it on Thursday. In the meantime, I'll sit with my lord. I will take appropriate instruction also.
because he's saying that the board was there
My lord, I'll my lord, check it.
on 21/9/2021.
My lord, why I am saying, my lord, kindly see page annexure 7 also. Order passed by this honorable court.
Yes.
Operative part, kindly see.
No, you see, Silchar Municipal Board doesn't mean that the board.
No, my submission in 2021, the board was there. The chairman was NN Tegur was there at that point of time.
No, whatever, we'll take notice.
Then after completion of 5 years, it was over.
No, that's okay. We only need that when was the elected board functioning?
Exactly. my
Yes,
lord. Your
only
lordship,
that much.
pass an order, I will get the instruction.
Actually, what happened in this case, my lord, father while was alive, said that.
No, it's okay. We are not interested
No,
in
no,
that.
I am only.
No, you see, it doesn't
only
help me.
only.
If I'm taking up the matter, then it's good to hear.
No,
Otherwise,
actually, son will get 1/4 share. So he will not be able
No,
to
no, Mr.
construct.
Ghosh-
So
Mr.
one
Ghosh,
sale deed was
we
executed.
have
in favor
thousands of
one
matter.
son.
I won't keep anything in mind. Just try to understand my predicament. If it is an effective hearing, you tell us anything you want. But if it's not an effective hearing, no point hearing. There are so many member friends of yours sitting behind.
And my lord, in fact, my lord, since my name did not reflect,
It's okay. We'll
I
ask-
could not bring my.
It's okay. We'll
brief
get your
also.
name in that. The stand of Mr. S.K. Ghosh, learned counsel for the petitioner. Is that on (21/9/2021), the elected board of Silchar Municipal Board was functioning. And he submits that, and he submits by referring to Annexure 8 to the writ petition, which is an order dated 4/3/2023, passed by the Executive Officer, Silchar Municipal Board, that it is projected in paragraph 2 thereof that the Silchar Municipal Board had taken a decision on 21/9/2021 to keep the mutation process pending till disposal of the civil suit. Stop. He submits that as per his instructions, such a decision by the Silchar Municipal Board was never taken. Stop. Next paragraph. Mr. M.U. Mahmood, learned counsel appearing for the respondent number 4, submits that perhaps on 21/9/2021, the elected Silchar Municipal Board was not there. Next paragraph. Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta, learned counsel for the respondent numbers 2 and 3, submits that as his name was not reflected in the cause list, the listing of the matter had escaped his notice. He submits that on a specific order being passed, he would obtain the specific instructions as to whether on 21/9/2021, elected body of Silchar Municipal Board was functioning or not. So in that event, he would also obtain notice that the date on which the executive officer took over the charge of Silchar Municipal Board. Next paragraph, the registration reflect the name of Mr. S. Datta. Your presence I have not recorded. Ms. S. Datta, government advocate appears for respondent number 1. The registration reflect the name of Mr. S. Datta, senior counsel, along with his instructing counsel in the cause list for respondent numbers 2 and 3 while listing the matter next. Next list on. By when you will get it? Give us a date.
At least a week time maybe.
Give a date. You have a calendar there. Give a date. What?
2nd of May, my lord.
My lord, 2nd of May, I will not be
here.
Then convenient date.
3rd or 6th then?
Yes.
First, 2nd and 3rd,
So 6th then?
6.
Okay. 6/5/2024. You need a mention, you send this download copy? No,
No. Not so bad.
not. Because the issue only boils down if there is a board.
Right.
Then there's a Ghosh is projecting that under section 80, the decision is to be taken by the board. But if the board is not there, then executive officer is taking a decision.
Yes,
That's the only point.
the executive officer can, my lord, he has.
So
the
that's
power.
okay, but once the board is there, the acts is board.
Right, that is right.
So if the board is there, then the executive can't
Okay,
take. And he says that
executive
the,
officer existence is not there.
and he says that the board never took a decision.
Right.
He's challenging that. Oh, so then I'll also note that.
Right.
Just in that one. In that first part, at least should be here you had. The respondent numbers 2 and 3 shall also produce a copy of the of the proceedings of the board dated 21/9/2021, which is found mentioned in annexure 8 of the writ petition.
Obliged.
I remember one gentleman, if the board is not in continuing or functioning, then government may take up and the government may authorize any person, he can do anything on behalf of board. Just like,
No, for that we don't need any decision. That is something we understand.
Yes.
Because if somebody is functioning, he functioning with full
with
authority.
all powers.
With all powers. And the fact is that they are not sure, nobody is sure
Yes,
what
yes,
is
that
happening.
Let's see the factual situation.
Okay. Item 40.
Item 40.
May I please, my lord? My lord, the respondent 5 had filed the affidavit and I have filed counter affidavit. Others have not filed any affidavit.
Just a moment. Your writ petition would not be maintainable. Pardon? Your writ petition would not be maintainable. Your mother is alive or not?
My mother is alive.
Then your writ petition will not be maintainable. You can't file in representative capacity a writ petition.
No, the land has been mutated in my name. That's how I have come.
No. You can't take two plea. You are taking a plea that the mother of your land was acquired. The land of your mother was acquired.
Yes, the same land had been mutated in my name and I have been paying revenue till 2023.
Okay, where is that statement? The land is mutated in your name. Where is the document to show that mutation?
That's on page 18, my lord, the translation on page 19.
Where is your sale deed? Or gift deed in your favor?
As per order of circle officer so and so, mutation case number so land covered by diagnosis.
It can't be done. A circle officer in its it does not have power to give mutation in the name of any other family member when the mother is alive.
But it had been done, how it had been done, I didn't know.
No, you are seeking a direction of the court. You will have to come with clean hands. You will have to tell us why it has been done. You can't assert your mother's property just because circle officer says yes.
I will be allowed to substitute the petitioner, my lord.
We don't know. You take your call. I am not saying what to do. I can't take a advisory role. You take your decision. You tell us what you're wanting to do, because
I may be given 2 weeks time, I'll substitute my mother in my place.
no, whatever you do is you're just adjourning it.
Yes.
Uh, You're Mr. P.K. Bora,
PK Bora.
Mr. P.K. Bora, then counsel of the petitioner. Also heard Ms. S. Barber, and government advocate, and Mr. A. Bhattacharya, and standing counsel for the Revenue Department, appearing for all the respondents. Next, on the court query as to how the name of the petitioner was mutated when his mother is alive. The learned counsel for the petitioner pays for him 22 weeks time to obtain instructions and to take appropriate steps. Mr. Matter stands adjourned today, this after 2 weeks. 41.
Wait, please, Malaj. Application under section 11(6), the arbitration estimates for appointment. Respondents had sought time to take instructions in the matter, Malaj, on 2 occasions previously.
Who's appearing for NF Railway?
Oh, Mr. H. Gupta appears, Malaj.
Name there in the cause list. Just give us call, Mr. H. Gupta, CGC, H. Gupta, CGC. Just wait for some time.
Item 42.
Next is a lot. This is an application for appointment arbitrator, my lord. Pursuant to last order, my lord, respondents are supposed to file their this reply, my lord. Opposition.
Yes. No objection.
Lordship, I have received instruction, as per my instruction, Lordship, annexure 14, Lordship, page 149. This is the communication by the department to the petitioner, Lordship, by which 4 retired railway officer, name of 4 retired railway officers have been sent to the
Now under the new act,
Lordship.
if the petitioner may not agree with this.
Lordship. Since they are from the.
Sorry, my lord, I am for item number 43, my lord. So, I'm sorry, my lord. This is
Yes. So we,
They have not responded to this communication, Lordship, therefore no action should be taken on in this case.
you see, it doesn't help us.
That's it.
Because you see, read paragraph 15 of the rate petition. Read paragraph 15 of the rate petition.
That's it. Yes, that's it. Section 12, subsection 5. Yes,
So why will he respond? He's telling the court that it is contrary to 12.5.
yes.
And you say that he has not responded. Why he'll respond?
Let's say I will file an affidavit in this case.
No, now we appoint someone. If you don't file an affidavit, your instructions, you can't keep these matters pending. You got a notice and then you don't file an affidavit.
Yes, let's say.
We give you 2 weeks time, you file it by then, otherwise we close this matter.
Yeah, yes, let's say I will file also.
But Mr. D.K. Kapil on counsel of the petitioner. Ms. R. Devi Leonard, CEC submits that as per annexure 14 to the rate petition, the petitioner was given an option to choose one out of 4 retired railway officers to be the arbitrator. So two out of them to be the arbitrator. 2 out of 4. First off. It is submitted that as the petitioner has not responded, or no steps could be taken. Such instructions from the NF Railway authorities disclose that the concerned authorities perhaps have not read paragraph 15 before 15 of the writ petition before responding. So one last opportunity of 2 weeks is granted to the respondents to file an affidavit in opposition in the matter, failing which the respondents are put to notice that the court shall invoke the doctrine of non-traverse if no affidavit in opposition is filed, and appropriate orders will be passed on the next date. Next part, this one, we will fix it after 2 weeks. Obvious. You see, Ms. Devi, and I'm speaking through you to all the learned counsel. You see, every day when you have 40-50 files to read, and naturally when you don't assist, there's a tendency to become autocratic. And that would be a sad day for the bar. You will not be heard. Because I would not be taking time to dispose of matters. I'm going slow because I want the lawyers to interact with the court and to give assistance to the court. Because I was there. In my time, had I not got an opportunity of addressing the court, not to be able to speak before the court, I would not have reached this place. But at those times, we gave assistance to the court. If you leave on me to read it and come, I in fact don't need an assistance. I'm quite capable of handling these matters without the assistance of the lawyers. Keep this in mind. And I don't, you see, my nature is to forgive. But my nature is not to forget. Please keep that in mind. I may forget a name, I may forget a face, but I won't forgive. Sorry, I won't forget. I can forgive, but I won't forget. That's the bad part. So if you can give assistance, you give assistance, otherwise take an adjournment. But to make the court read, then you are in the receiving end. And if I become autocratic, which I am quite capable of doing, I can tell you it will be the sad day, because then a counsel who wants to speak will not be given an opportunity to speak. Please don't allow that thing. Please give assistance if you have read it. If you have not read, don't come.
Okay.
Item 43.
But in this case, my lord, I'm appearing for the respondents, my lord. I was required to file my affidavit. But I have received the Paravice comments on Saturday. But I pray for some time to file.
How much time?
Well, it's 3 weeks time.
Both sides are represented. Mr. E.R. Adhikari.
M.R. Adhikari.
M.R. Adhikari, learned counsel, you're appearing as CGC.
Yes, madam.
Learned CGC, praise for is granted 3 weeks time to file affidavit in opposition.
Right.
List after 3 weeks.
The next item is similar.
Same, madam. Similar.
Next item is similar, my lord.
Same. Okay. You are being
Yes,
there
yes.
also. Okay, 45 of last. Oh, acha, this arbitration matter, I forgot. Please come forward. I'm sorry, it escaped my mind. When I saw you, then I remember. Once this objection is taken, we would propose to appoint the name of Mr. Honorable Justice retired Achinta Malla Bhujar Barua.
My lord, he's already been, he's heard this matter, my lord, that he has heard this matter and there was an order in that regard.
He's heard this matter.
My lord may select a name from the list of arbitrators of the Guwahati High Court, of the High Court judges and the Supreme Court judges.
Spoken that list. He had decided this matter.
He has heard the
it on one occasion.
No, hearing is, you see, that doesn't have an impact. If there's a decision, I can understand.
He had heard the matter, my lord.
No, but that hearing is not it's a conclusive hearing.
My lord, it was almost.
No, those things don't matter. If the judgment or any order is passed by the same honorable judge, then we can understand that he will have some influence. But if a matter has been heard, you see, those permutations and combinations would be so different, so difficult. Let us say there are 10 honorable former judges.
My lord.
The lawyer had appeared before the same former judge. The lawyer had engaged the said former judge earlier. Those things, if we try to calculate, we will not find an independent, so-called independent honorable former judge here in this court.
My lord, as per the list is H.N. Sharma and C.R. Sharma.
There's another reason for not appointing. I think they will be having that qualifying age.
No, this list of arbitrators is.
There's a qualifying age.
Yes, my lord.
You're aware of the age?
Yes, my lord.
We don't know that. It's a list of last year. Because hearing a matter of the appointment of arbitrator doesn't go into the root of the matter. Nobody looks into the agreement. I've been compelled to do it because of the fact that those issues were raised before
Yes, my
us.
lord. So, my lord, as my lord deems, my lord.
Because otherwise we'll find it very difficult. Because if he has objection, he'll disclose it under 18.2. Otherwise, it's very difficult. Okay, we'll make that necessary correction in the order. So this order of order will be modified to that extent.
Appointing former Justice A. Bhujar.
Justice A.M. Bhujar Barua, former judge of this court. Okay.
Deeply aware.
Item 45.
Yes.
Please, my lord. My lord, the specific
issue that is before my lord is whether after the expiry of the tenure of the market committee, which is for 3 years, whether further extension can be granted and whether it is a discretionary power of the state or whether it becomes mandatory if no elections are held within the particular time as stipulated under the act. If my lord looks at section 9, clause 1 of the Assam Agriculture Produce Market Act of 1972.
You have annexed the act here.
No, my lord. I have an extra copy.
Pass it on.
Section 9, clause 1, my lord, page 35.
Section 9.
Yes, my lord, clause 1.
That is for the first time.
No, my lord. Every member of the market committee other than the first one. Section 9, clause 1 deals with the market committees that are subsequently elected, apart from the first.
Other than the first one. Okay.
Yes. Shall hold office for a period of 3 years, commencing from the date of first meeting of the reconstituted market committee at which a quorum is present. The market committee shall thereafter be reconstituted every 3 years before the expiry of the third year and not earlier than 3 months prior to such expiry. Therefore, my lord, the mandate of the act is that before the expiry of the market committee, a new committee should already have been elected, and the election process should have been completed before that expiry of the tenure. However, if that is not done, that is also envisaged, my lord.
But we can't, you see, we can't do anything. You have to, once they have disclosed in their affidavit, that there's a order passed in a writ petition of 19/8/2021.
My lord.
Directing a status quo to be maintained.
Yes.
Then what is the scope of this writ?
Because, my lord, they have come and submitted before the court that the petition had become infructuous. So the previous petition had to be closed. Now, since the status quo until further order was directed to be maintained, by strength of the judicial order, I was holding office. Now they have unilaterally come and said that since that extended 1 year period is over, therefore nothing remains. Now, whether that is permissible, because we had already put a representation before them to consider our prayer for an extension as per section 9.
No, extension can't be at your, it be a decision of the government. You can't. You can't say that you are qualified. You'll be assessed with others.
If my lord kindly looks at section 9 clause 3, it empowers the state government from time to time to extend the tenure of the existing market committee if for some reason the elections are not held.
We have a very dismal picture of this Assam state agriculture produce market.
My lord.
Have you seen any Anaj mandis in any other place in the country? Any place in the south or Haryana or Rajasthan for that matter? Have you seen any Anaj mandi?
Yes, my lord, I have been to some of them.
You've seen Anaj mandis. Just give me an idea. What have you seen in this Anaj mandi?
The vegetable producers would be coming and going, and
no. It's not that. In an Anaj mandi, there'll be huge facilities of weighment, of loading, unloading, transporting, then quality control, the inspections of the vegetables. Here, this court had passed an order to check the quality of vegetables because of the insecticide.
My lord.
Few days it worked. And I can tell you, I have visited a few market areas from where the vegetables come into the state. There's no check gate. The marketing board doesn't do anything.
My lord.
Tell me one facility in the Assam marketing board where you have any facility which is. Anyway, you give me a name of the state and I'll tell you where is that Anaj mandi.
Yes, because we have very limited funds as a marketing committee. The board mainly regulates us.
You are asking for an extension, that's why I'm asking.
My lord.
If you have seen any announcement, then you will come to understand that there are some facilities given.
My lord.
For a trader to be there. And not even two of such facilities which exist in other places. You want to know about Anas Mandi, I'll tell you, facilities in Anas Mandi. You want to have Anas Mandi of which state? Rajasthan?
As a lordship pleases.
Or Haryana?
My lord, even otherwise, my only grievance is that since they have not conducted the elections as per the act, till they conduct a fresh elections, I may be allowed to continue since I was democratically elected. And the officer that they have deputed is not empowered under the act to continue as an ad hoc chairman. That is my limited grievance, but.
I can get the Mandi Bhav, Mandi rates. Bhav means we tend to speak in Hindi. The Mandi rates of each and every food grain at the Haryana Mandi, I can tell right now. Just show it in. There are a lot of things there, but those are not material for agriculture waste. But this you will find, these last two boxes. So everyday rates of the food grains, you are getting it. You can just click it, you will find the rates. Jowar, bajra, wheat, everything is available. The facilities are immense.
Yes. Precisely, my lord, the marketing board here is not efficient enough. And that's why they were not able to conduct the elections on time. But because of their inefficiency.
Those efficiency we don't need. The assistance you give to a person who comes with food grains, that is something we want to see. They're loading, unloading, nothing is there.
Yes.
You'll find in the wheat loading market in Haryana, they are mechanized, what you call, loading and unloading facilities. There is no hand, it's not manual.
Yes.
They will do it by, what you call, they have those machines too.
Machines, the cranes that take it. Yes.
No, not cranes. There's a dump and from the dump it carries it and will give it to the trucks. Okay. Huge facilities.
Yes. My lord, this is precisely the reason that
the agriculture market in Jodhpur, for example, you will find tea stacked there, which is more than anything you will find in Guwahati. The combined quantity of tea held there would be more than much more than the tea quantity you will see in Guwahati. Even if you go to those warehouses.
Yes.
Comparatively, you will find in that grain market quantity of tea. I'm just speaking of one thing which is dear to Assam.
Yes, yes.
Those are things.
We are lagging behind, my lord. So for agriculture, it's concerned.
Yes, what is your stand?
And for the department, Lordship, for the board she is appearing, his tenure is already over, Lordship. His extended tenure got over on 39/2022, Lordship. And so Lordship, by virtue of order dated 17/11/2023 Lordship, in page 52 of the writ petition Lordship, he was continuing till the interference of this honorable court Lordship. Page 52. Of the writ petition.
But then you please tell us, if his tenure is over,
Lordship.
then this marketing board itself becomes, what you call, it becomes defunct and illegal body.
By virtue of section 48 Lordship of the Assam Agricultural Produce Act, section 48 Lordship. The state government may delegate by notification in the official gazette any of the powers conferred on it by or under this act to any of its officers or to the board or to its chairman or chief executive officer Lordship.
No, but you
This
see,
is a temporary arrangement Lordship since 17/11/2023 till date Lordship. And in our affidavit, we have categorically stated that Lordship will conduct the elections.
where is that?
Allot para number 12 and 14 of the affidavit. But they have not specified
Para
any time
12.
limit. They have merely said that we have asked the
Para
district agriculture
12 of our
officer.
affidavit, page 59.
There's no timeline, my lord. Within what time they will conduct the elections. Just a blanket.
After the general elections are over, Lordship, now. That as regard to the statement made in paragraph 11 of the deponent begs to submit that the tenure of the marketing committee as well as extended term is already over. Therefore, the department has taken steps for conducting election and to this effect has already issued direction to the district agricultural officer Nagaon.
You tell us, you file an additional affidavit, tell us when you are proposing to do it. From 22, you did not show any eagerness to constitute it.
Because
Yes.
of the interim order continuing, Lordship.
What is the interim order?
Status quo order, Lordship.
Hmm?
And status quo order to maintain status quo.
My lord will find it at page number 47 of my writ petition.
47.
Yes.
47 is the order of the IA, Lordship.
Wherein it was directed that the interim order passed earlier shall continue until further orders, my lord.
And the case was listed very late, Lordship, on 17/3/2023. Lordship, may kindly take note of the conduct of the petitioner, Lordship. He has never appeared on 2 occasions.
No, that's okay.
After
If they don't
Good day,
appear,
interim
the court would have dismissed it, so therefore it's not this conduct.
17/3/2023, Lordship.
This is which writ petition? 4665.
Yes.
4665 is already closed.
Yes.
That is the IA.
4665 was
Yes,
closed in
it's-
1711. So after
Because of the
17,
order dated 17/11/2023, Lordship. Till that time, he was enjoying the interim order.
that's okay, but after
Now
this.
that as
40,
per section 48. Section 48 of the Assam Agricultural Produce Act, Lordship. The state government has delegated the power to the chief executive officer. That is the district agricultural officer,
No,
Nagaon.
no, you tell us, you file a affidavit within next week, by which date you are holding this election. You tell us. Otherwise, nothing will happen.
Yes, election, we have to continue. We have
You
to
tell us,
conduct.
file an affidavit within a week.
Yes.
Or Mr. Ibarwa, counsel for the
My lord, if
petitioner.
I may kindly submit one thing. Even otherwise, my lord, if they pass that order, they're not empowered to appoint any officer when that market committee tenure has expired. Under rule section 48, they don't have that power. That the delegated
So
power,
who will run it?
the existing committee will have to run.
No,
it.
no. We can't permit that. Once an election tenure is over,
Yes, ma'am.
we can't permit you to hold it.
My lord, by virtue of section 9 clause 3, that's why it has been provided that the market committee's tenure can be extended from time to time.
No, we not permit that. You can't be
Only for
endless.
1 year, Lordship.
My lord-
Extended term only for 1 year.
My lord, the order is illegal because it could not have been passed. Because, my lord, the district agricultural officer has been made the ad hoc chairman. And he's also the member secretary of the election authority who will conduct the elections. So therefore, how can he discharge two duties at the same time?
Government officer can do it. We don't have any malice against them. We are not alleging malice against them. But
No,
that's why we are wanting a deadline when
Yes.
you are doing it.
We have to conduct elections.
No, have to is okay. But when will you?
Yes, I'll file an affidavit.
Have to is okay, but when will you? Consider the petitioner. Submits that notwithstanding the expiry of his tenure as the
Chairman of the
chairman of the Lanka
regulated market committee.
Regulated Market
Committee.
Committee. The petitioner is entitled to an extension of his tenure. Under clause 3 of, sorry, subsection 3 of section 9 of the, right, 9(3)
Yes.
of the Assam Agricultural Produce Market Act, 1972. Next paragraph. Mr. Bora, and standing counsel for the Agriculture Department submits that the extension envisaged in section 9 within bracket 3 of the 1972 Act is only for a year, and that the tenure of the petitioner had expired on
39/2022.
9/2022, and he has already enjoyed the extension of his tenure for more than a year. The petitioner is no longer entitled to any further extension of his tenure. By referring to notification dated 2/3/2022 within bracket annexure D to the affidavit in opposition, it is submitted that the district agricultural officer has been directed to complete the election process of district regulated market committee.
My lord, that is not a correct notification. My lord will find it at page number 53 of my writ petition. Notification dated 20/12/2023.
No, but they are relying on this to 2nd March. Page 66, that is the, they are relying on.
I think this was withdrawn.
Is it?
Yes, this was withdrawn because this was in the teeth of the judicial order of interim order. Or the status quo order.
60 was withdrawn.
It was withdrawn.
It was withdrawn. Then what is the
Withdrawn.
next one?
Then, my lord, the current impugned
change.
order is issued, my lord,
Pardon
at
me?
page 53. 53 of my writ
Of the
petition, my
writ
lord.
petition.
That is the impugned order, the current order.
Okay.
20/12/2023.
By notification dated 20/12/2023 within bracket annexure M to the writ petition. The district agricultural officer Nogam was permitted to take over charge of Lanka Regulated Market Committee as ad hoc chairman. And in the capacity of the district agricultural officer, he was directed to take necessary steps for holding the election process of the regulated market committee in appropriate time. Stop. Next, paragraph. Having noticed that the elections have not been announced till date, the court is inclined to direct the district agriculture officer, which place?
Nagaon.
Nagaon. Within bracket. Within bracket, respond number 5. To file an affidavit before this court to give an estimated timeline within which the election process would be completed. Next paragraph. Insofar as the prayer for interim relief is concerned, the court is of the considered opinion that as the normal tenure of the petitioner, as well as the extended tenure of the petitioner as chairman of the Lanka Regulated Market Committee has expired. The term of the petitioner being an elected chairman cannot be further extended. Therefore, the prayer for interim relief to drag the to allow the petitioner to function as the chairman of the Lanka Regulated Market Committee is refused. At this stage. Give a date after 10 days, a non-hearing day. List on responsible for affidavit by respondent 5.
I'm obliged.
Obliged.
Oh, I'm sorry, there's a meeting I overshot. There's a meeting was 4.